paragraph of this page.
Yes, madam, they paid
Line.
17.
Hence, RTP is requested. It should be
But that
done
was
as
requested to appear.
So this was requested. There has to be something to this.
Yes, yes, madam. It পেয়েছো? না কেস নাম্বার ক্রিয়েশনটা ঠিক হচ্ছে না।
There is some
কেস নাম্বারটা ক্রিয়েশন ডেটটা দেখো না।
Where is your amendment? Show me.
Lordship, paragraph 9. Paragraph 9. Page 4.
এই দেখো না দেখো না। সরো সরো সরো। Adjudication case ID.
Page 4, paragraph 9. It will start the page 3.
কত হচ্ছে দেখো।
Stated that the petitioner was directed to appear with all relevant documents on, but no such communication was ever made by the respondent to the petitioner, which is a blatant violation.
Very well. Mr. Rai, come back in May. Come back in May.
I am also not pressing for any because after May,
It was asked to appear personally.
But I have one which says on the portal RTP is requested to appear before the proper officer on 5th February 2024 11 hours with all relevant documents.
but it was written on 2nd February.
But that is what I have on the portal. But that will become irrelevant if it's 5th he has received it. Because my finding would be only a mistake, a mechanical mistake. So that will not, I will only have to show that he had notice of this and he was given. That's it.
When portal is there in the portal?
Yes, yes, Malad.
Was done.
I find that there is something on the portal, Malad. But let me come back. I'll
Yes,
find an
yes,
affidavit.
Sir, either you can show.
Yes, yes,
or
I
this
can
goes
show.
back. Simple.
Yes, yes, Malad.
There is no in between
Yes,
things.
Malad.
The question, alleging
এটা কি?
failure of natural justice. Alleging failure.
No, not Malad.
No,
Why you wanted a portal?
Application has been filed
already. They have mentioned that.
It's a portal.
challenging
No.
challenging the order dated 7th February 2024
Portal
passed under section 73 of the West Bengal GST WB GST Act 2017 Goods and Services Act 2017. It is contended that the respondents, despite it is contended that the respondents, without giving a personal hearing to the petitioner, despite recording the factum of personal hearing in the aforesaid order, comma, again for a comma, had disposed of the said proceedings by passing the order dated 7th February 2024. Post up. Mr. Rai, learned advocate, Mr. Rai, learned government pleader, appearing on behalf of the respondents, prays for an accommodation to the instructions in the matter. He submits. Will I record that it has been served? No.
Well, my
Instruction only.
submission has been served. I will get.
I say only instruction.
Well,
Full stop. Having regard to the aforesaid, list this matter. Having regard to the aforesaid, let this matter stand adjourned and be listed in the monthly list of May.
Not in monthly list. Fix a date.
It will be
Your
called on in the monthly list, sir.
If it is,
Sir, it will be called on in the monthly list. Why are you so apprehensive?
No.
If it is not called on, then come back.
Lordship, this.
Yes. Mention the matter.
why not we pass an order in mention? দুটো করে একটা করে করে দিচ্ছি।
So I've recorded his submission. I've recorded your submission. Not your sub. I've recorded you want to take
Yes, yes.
instruction.
But it is there only I find, but I'll point out. According to me, Malad, there is one discrimination or fifth and second. So that is why I just need to clarify. If it is fifth and if it's written the second, I will still argue.
Argue that.
Lordship,
Sorry, Malad.
Argue that on that day.
And that I will argue. That should be a problem.
Yes.
With your lordship, Malad, I don't think that is going to be a problem.
No, no. Sir, if he is entitled to a relief, I'll
Just
grant
got a
him that.
notice, that order
If he had no notice, I'll grant him to a relief.
got a notice. Now he can say that the order records a separate date. If I can show he had the notice for that matter to appear on the 5th, that would be just a mechanical mistake. In a final order, that would not change the order. That is what I will be arguing.
What would be the difference? 15 days time to dispose of the proceedings once again? Nothing. Nothing. Same thing will come out.
I know that they have got
Yes. And he has to prefer an appeal. This court is not going to interfere. Yes. Appealable order.
this
Yes.
is Lordship.
This
I
is
just-
violation of principles of natural
That's
justice.
what he
that is
says.
not appealable.
But upon otherwise appealable order.
It's an appealable order, but I am just asking for the
If I can show that there's been
Remand
violation-
because it is not an useless formality, your lordship. Had it been a useless formality,
No,
just
no,
why
I'm
sign?
not on that, sir.
There are many things, your lordship, which is absurd in the order itself.
That I cannot go
No,
into
no, no.
this.
But why I am buying time? Just I am asking for remand because let the matter be heard.
We have
in the-
succeeded there. Let us come to the X factor. Yes.
Lordship.
Hey, Dapo, Dapo.
Item number 5,
On the ground of violation of principle of প্রথম লাইন বলা আছে চ্যালেঞ্জিং দি অর্ডার রেট এত প্রথম লাইনটা on the ground of violation of principles of natural justice.
My lord, the petitioner is a retired doctor, my lord, is an NRI. And after 10 years, my lord, this is related to the assessment year 2015-16, financial year 14-15. He received a notice from the Patna division, where his residence is, original residence. Notice under 142(1). After making a reply from the other side in the e-proceedings, the matter was transferred to the International Taxation Division, Calcutta, my lord. There, a so-called notice was issued to us. Then a date was given to us, my lord, on 15th of March 2024, my lord. On 15th of March, my lord, when I appeared before them, my lord, I was informed that the order has already been passed. I received an email, my lord, which is on
You were required to appear on 15 March.
the so-called notice, my lord, to appear to
Where
submit.
is that?
My lord, I'll please.
No, I'm Ari.
Yes, my
It says 15th of March you are required to be
Yes,
present.
yes, the
And it
notice-
was disposed of by then.
My lord,
wrongly done.
let me complete, my lord.
Then I'll set it aside, send it back.
Yes, Lord, that is
My lord, what has happened, my lord? Let me complete. 14th, the mail has already been given to us and order has been given to us with the order dated 15th, my lord. How on earth, my lord? A order dated 15 can be emailed to me on 14th. My lord, please come to page number.
Let us not go into this. I'll
Lord,
set
if he
aside
goes
that.
into this, my lord, I'll use an affidavit.
Then
my
you
lord,
have to
because
use
that-
affidavits. There's a lot of
that is
things.
wrong. My lord, when he says, my lord, that an order dated 15th was served on 14th, my lord, I will oppose that, my lord, because the order is digitally signed. If your lordship sees the order, my lord, the order is it is definitely a mistake on the part of the authorities, my lord, to have fixed, my lord, the hearing
Where is
at
that order?
11 a.m. If your lordship sees the order, my lord, the order is at page, my lord, page
70
28,
71.
page 71, annexure P28 or P8, my lord, it appears as to page 71. Your lordship will kindly take page 73. Page 73, my lord has taken.
I can't read the date here.
My lord, your lordship will see the day. Day is Friday.
Oh, Friday.
Friday.
So Friday should
No,
be.
my lord, Friday was 15th.
15th.
Because your lordship will kindly see the email which my learned friend is referring to.
Page
My lord,
70,
the
my lord.
email is page 70. Email which my learned friend is referring to is at page 70. 70. My lord, kindly see the date there. Day there, it's Thursday. Thursday is 14th. Therefore, my lord, this order is signed, digitally signed on 15th. It could not have been signed on 14th. My lord, this digital signature, my lord, will happen on the day it is.
But how come it can be sent on 14th?
Now,
my lord?
therefore, my lord, I will have to inquire and I'll have to, my lord, oppose him on affidavit as to whether this email has originated from the department or not. My lord, if your
My
lord,
lord, how a DIN number can be
Yes.
generated?
Very
How
well,
a
my lord,
DIN
then
numbers
I will
can
have
be
to come up
generated
with
online?
affidavits, my lord. If he wants to challenge this and want to have a contest on
Not one, my lord. There are 3 defects in the order, my lord.
the order, I'm saying that the order is defective, the order can go
On 3
that
counts,
ground.
my
But
lord.
if he wants to contest this email, my lord, then in that case, my lord, I will have to stand my ground.
Let it be set aside, my lord.
Yes. If he wants setting aside, yes, I am also agreed to it, my lord, that it should be set aside, my lord, as an officer of
You are saying that this did not go from your office.
my lord, my instruction is, my lord, that how did this go, whether this is email of our office or not, my lord, these instructions are, my lord, wanting. This is the email, my lord, kindly have a look.
If that is a very serious question.
Yes, kindly have a look, my lord, this.
Where is
That
that
is
from?
why I said, my lord, he can have it. He
My
can have
lord,
the order
even-
set
No,
aside.
no. In that case, let this issue come up, because you see, this email is not this date cannot be put on the email. It is with a date stamp. This is with a date stamp. You see, this is with a date stamp.
Now, my lord, the attachments, my lord, the attachment says such and such generate order under 144C. Then there is another attachment. My lord, we
That
have
is-
no idea of whether
That
the attachment is
so-called
the same.
notice. That attachment is a so-called notice.
Then, my lord, whether this attachment is
14th
the
of March was, 14th of March was
Thursday.
Thursday, my lord.
a Thursday.
Now, my lord, whether that attachment contains this order or that attachment contains something else.
Order was digitally signed on Friday.
Yes,
Friday, my
So
lord.
15th of March,
yes.
Yes.
let us understand, wait, sir. Order was digitally signed on 15th of March.
Yes.
So it could not have been signed a day earlier. The date, but you may have a point that the date was provided for as 15th.
Yes, that I also agree, my lord. I agree, my lord, that the order should go on that ground. My lord, on 15th at 11 a.m. he was supposed to have the hearing. If your lordship sees the show cause notice.
And apart from that, this is maybe a typographical error in the date itself. On the order itself, on
My-
15th, it was signed on 14th. Try and appreciate, sir.
Yes.
It was signed on 14th. It is not that the order is antedated.
No, no.
I'm
I
mentioning.
would have appreciated it is antedated. It is post-dated after the digital signature. Digital signature is on 14th.
15th.
My lord, it is antedated, my lord. Because the order dated 15th has to be generated through DIN number. How a system DIN can generate an order dated 15th until unless something has been done there. And the email has been
I
sent on
couldn't
14th.
follow. Please come again. Yes, yes.
My
yes.
lord, I have mentioned in my paragraph, my lord.
Yes, yes, yes.
My lord, it's paragraph 8. Yes, my lord, paragraph 11, my lord. Late afternoon on 15th, the petitioner informed his lawyer that he has received a draft order dated 15/3/2024 under section 144C1 of the Income Tax Act from respondent number 3 of the Income Tax Department. But on 14/3/2024 at 11:25 through email. Now the
Oh,
owner,
this you have received on 14th.
yes. How the 15th order can be received on 14th until unless there is a time machine.
And digitally signed on 15th.
Digitally signed on 15th, my lord. Now the onus is on
Something very
respondent number 3
strange.
to
But if
explain
it is digitally
how
signed
on
on
earth it is.
15th, my lord, it has to be 15th. It cannot be digitally signed on 14th, my lord, with a date on 15th. My lord, if it is digitally signed on a particular day, the date of that day, my lord, will be captured. If your lordship sees the date, the time at which the order is signed, my lord, kindly see the time, page 73. Time is 1:24 a.m. 1:24 a.m. This is the time. It has to
Sorry,
be
sir.
15th.
This you have not affirmed as true to knowledge.
My lord,
This you have not affirmed as true to knowledge. This is your submission. You have been very categorical. Come to page number 54 of the writ application. You've taken a chance. Paragraph number 11
54, my lord.
of the writ petition.
Yes,
Second paragraph.
yes,
Your affidavit.
yes, my lord.
Please read the affidavit.
The time the writ petitioner and the searcher was acquainted with the facts and circumstances incident duly
This
complete.
is not true to your knowledge. You don't have knowledge on this. You say on record. What records? What records?
Records, my lord. Records not mentioned, my
The
lord.
statements contained in paragraphs 1, 5,
Yeah.
10
Yeah.
and 8, 10, 18, 11 is not here.
Okay.
Are true to my knowledge. So it is not true to your knowledge. The statements made in paragraph 11 is included are matters of record. What record?
I record this, the income tax record, my lord, which the
His
client
name.
has with this lawyer, my lord.
The mail is his.
That is your knowledge.
Yeah, my lord. Whatever the case may be, my lord, I've mentioned in paragraph
Where is
11.
your statement that you verily believe to be true?
My lord,
This record you believe to be true?
my lord, it's true, my lord. My lord, now the fact remains, my lord. I've mentioned very clearly on paragraph 11. Now the onus in the respondent number 3 to explain that how on earth is possible that an order dated 15/3 can be emailed, antedated, backdated on 14/3/2024, my lord. Not only on this ground, my lord. Please come to order again, my lord. My lord, the permission which is required also, my lord, the notice, the so cause notice. My lord, first paragraph, last line, my lord. After following procedure norms, my lord, page 71, my lord.
Can you file your affidavit?
My lord,
This
15.
should have gone, my lord, easily, my lord. This
No, he has other points. You see,
very well.
one thing he says, this line is troubling. 15th order, how could have been emailed on 14th? What is so special about this case? That this email is generated on 14th with a digital signature of 15th.
Lord, if the digital signature is of 15th, my lord, it could not have been sent on 14th.
But if the email says so, you have to, when did you receive this petition, sir, Mr. Rai?
Lord, I received this petition, Lord. Lord, I have my instructions. Lord.
Yes. What are they saying? What is your instruction? You just tell me that
Yes, Lord.
your instruction.
They say, my lord, that it was digitally signed on it and it
No, what about the email?
My lord, about the email, my lord, I have there is nothing written there. There is nothing written, my lord, in the instructions.
Acha, so what is your name, sir? You are Mr. Sultan. Mr. Sultan, come to page number 70. Under cover of this particular email, by way of an attachment to this email, you received that letter. Your statement in paragraph 11 is, email is dated 14th at 11:25. Where is that email?
Just first is forwarded to me. You go by the second from DCIT IT12, my lord. The timing is 11:25 p.m. Thursday night.
No, where is that particular email? Your email?
My lord, it's there only at page
There only, my
70.
lord. Second,
Page 70,
I've
my
seen
lord.
that. Where is that email? You see, this is from Shamim Reza
My lord,
that
below
was
that,
sent
to your advocates.
below the line, below the
No,
line,
I've seen that.
from
Mr.
Kolkata.
Rai, page 70 is his communication to his forwarding to his advocates.
Below that, below
No,
from
I want to see. Yes, it records everything.
Yes,
But this is forwarding. This is
Yes.
the forwarding copy.
yes.
Where is the copy you received? Where is
Where
the
is the copy
printout of the email you received? Where is that printout?
that is forwarded to me. my
No.
I get your lordship.
Mr. Reza, your name Reza, your Mr. Sultan. Mr. Sultan, come to page number 17. Who is Samim Reza?
lord.
Correct. Now, Samim Reza is forwarding this document to you. Perhaps MJ Sultan, you are Mr. Sultan. Yes, sir. He is forwarding this letter to you. You have annexed this document. Where is the original printout of the email? You are only annexing the forwarding letter, forwarding email. Where is the original email? This has been sent on 15th. Naturally, the next date. It records that it has been forwarded on 14th, but I want to see that also. This is not the email which he received. This is the forwarding email which you received.
Below, my lord, below the line, my lord. From DCIT, when you forward an email, my lord, when you forward
Ordinarily, that is there, but I want to see the printout of that original email he received.
But my lord, the email is already there.
This is a forwarding email which has been forwarded to you.
My lord, when you
No,
forward-
these are all, you see, these are not on pen and paper. These have been forwarded. What has been done there, I do not know. This is an authority which gives a appropriate explanation. He says that this order could not have been issued prior to the date on which it is digitally signed. Now, for that, you have to demonstrate before the court which particular email you have received. I'll direct you to produce that.
But again, another technical defect, my lord, is
And what are the other points you raise?
say paragraph, first paragraph, my lord, last line. After following procedural norms under section 148A, the notice under section 148 was issued to the SSC on 5/4/2020. No such notice was issued to me.
That is a question of fact.
There
That
are
I will
no
have to
notice
take
issued to-
instructions, my lord, because those are on merits. My lord, if he is challenging.
No, if the notice 148A has not been issued, then the notice is maintainable. The subsequent action is maintainable.
My lord,
Where is the where is the statement in this regard? Where is the statement in this regard?
There are looking for my-
Yes.
Lord, he has been receiving notices under 142(1), my lord. All these things, my lord, happen after 148 notices, my lord. I don't find in the
You take these points before the appellate authority.
My lord, this order is not appealable, my
Not appealable.
My lord, this is draft order. To that, my lord, he has to take an exception. He has to file, my lord, an exception before before the dispute resolution panel.
I
My
see.
lord, here, my lord, I agree with him, my lord, that there has been a violation.
So far
of
as this
principles
part
of
is
natural
concerned,
justice.
no, I understand. This has to go.
Yes.
Rest, whatever
Again,
the
my lord,
other
draft-
objections you have, you take before the dispute resolution
he
panel.
My lord, he will take these objections, my lord, he will take these objections before me only at this instance, because I will have to pass another order under another draft order under 144C. Lord, once he gets that fresh draft order, my lord, he will have his chance.
You
to
take
file
all
the-
your objections then.
draft order which has been passed by the officer, he cannot consider anything from his side. He will pass the same order, my lord.
No, I will set aside this order.
My lord, even the dispute.
You did not, before passing of the draft order, approach this court, challenging their action. Try and understand, Mr. Sultan. You did not. You waited for the authorities. You wanted to appear before them from the show cause notice.
Given date on 15. And when I reached on 15
That-
order,
So I am setting aside that notice. You take all your points.
set aside would be fine.
Yes,
My
yes.
lord, kindly take 144C, my lord, so that things are clear, my lord. My lord,
Hey, Akbar, dekhi, income tax.
kindly take.
Income tax.
Once the draft assessment order goes, it again starts with the draft assessment order only.
Yes.
Then
Yes.
Lord, 144C. Capital C, my lord. My lord has got, my lord. Lord, the assessing officer shall, notwithstanding anything to the contrary contained in this act, in the first instance, forward a draft of the proposed order of assessment, hereafter in this section referred to as this draft order, to the eligible assessee, if he proposes to make on or after the first day of October 2009 any variation which is prejudicial to the interest of such assessee. Now, my lord, this draft order had been forwarded to him. My lord, the procedure is that prior to forwarding of this draft order, my lord, he is made, my lord, aware of the questions that the assessing officer wants to raise. Those are questionnaires, my lord, under section 142(1), my lord. Questions are issued, my lord. Those notices are, my lord, preceding the annexure, my lord, which contains this draft.
But you issued a show cause notice to him also.
Yes, that is not his.
Where is the provision for issuance of show cause notice?
Yes,
Kindly show me
yes,
that
Yes.
prior to passing the draft order.
Yes, my lord, that provision is there, my lord, in terms of 148 only. If you lord,
Yes, just show me that
section
once.
148.
The assessment or recomputation under section 147, the subject to the provisions of section 148A. The assessing shall serve on the assessee a notice, along with a copy of the order passed required under clause B of section 148A.
And in this case, this has been done after 3 years.
After 3 years, my lord, that's
That
standard of
point he will take, my lord.
Yes.
We will clarify it. We will deal with it in the draft
Correct.
assessment order. It's only a draft assessment order. He is entitled to take an exception to that. My lordship takes, my lord, 144C again, my lord, so that, my lord, we reach the second stage. My lord, what happens thereafter? My lord, draft assessment order is not all. My lord, thereafter, my lord, 2, subsection 2. On receipt of the draft order, the eligible assessee shall, within 30 days of the receipt by him of the draft order, file his acceptance of the variations to the assessing officer, that he accepts it.
Or
This is
file
one
his
more.
objection.
Or file his objections, if any, to such variation with the dispute resolution panel and the assessing officer. My lord, he'll give a copy to me and he'll file the exceptions to the dispute resolution. The assessing officer shall complete the assessment on the basis of the draft order if the assessee intimates to the assessing officer the acceptance, or
Or no
if
objection.
no objections are received, And my lord, the assessee shall notwithstanding anything contained, my lord, thereafter, my lord, the dispute resolution panel will deal with the objections. It will pass the final order. And in terms of that, my lord, the assessing officer will finalize. Assessing officer has no role thereafter. My lord, he becomes a puppet. My lord, if only if his
It
variations
is for the
are accepted,
dispute resolution panel to
take
decide
a
this.
call. And thereafter, my lord, it becomes appealable.
But there also there is a problem, my lord. Please come to Provident Fund.
No, it's not be necessary at this stage to go into all
Lordship is not
this.
going to that extent. My lord, your lordship is only at the stage of draft
Does
resolution.
not have power to quash it, my lord, even it's a genuine case.
Your lordship is quashing it now. The draft resolution order, your lordship is quashing it.
Power to quash, my lord, even it's a defective order, my lord. Come to provision.
My lord, he has not challenged the proceedings prior to this. He has,
Shall not be set aside in any proposed variation of any direction under subsection.
my lord, he has all along been thankful, my lord, to the income tax authorities. My lord, his notice, his reply says so. My lord, he has, my lord, hailed us, my lord, in all respect. Your lordship will kindly see the replies.
69,
Then also,
I am not required to maintain books of
my lord,
accounts, my lord.
my lord, kindly
Because
take
being
page,
an
my
NRI,
lord, these are all on merits. Only if your lordship says, my lord, page 58.
Counts on defects, 3 counts on merits, department loses, my lord.
Where is the show cause notice?
My lord, show
B3.
cause notice, my lord, is at page 61.
It is in to the, you are to respond to this particular show cause notice.
You have responded, my lord. All the notice has been responded through e-proceedings and as well as through emails, my lord. That has also been annexed, my lord.
My lord, he would have had no grievance, my lord, to approach this honorable court at least, my lord, if what was written at
No,
page
before-
66, if
if-
what was written at page 66, my lord, had been complied with. My lord, this is,
Yes, page 66 has not been complied.
yes, my lord, because he was to appear at 11 a.m. on 15/3, my lord. Before that, we passed the order.
Where is this show cause notice dated 8th of March
My lord,
2024?
61. 61.
That is that particular.
Yes, yes.
The present writ application has been filed inter alia challenging a draft order dated 15th of March 2024, purportedly passed under section 144
C1.
C of,
It's a draft order.
yes, 144 C
My lord, 144
of the
C1.
C1 of the Income Tax Act 1961 inter alia on the ground of violation of principles of natural justice. Full stop. The petitioner claims to be a retired doctor and a senior citizen having an income tax assessee number PAN ওই আছে ঠিক আছে দিয়ে দিও Full stop. At present he is residing with his son at Saudi Arabia. Full stop. The petitioner, it is a petitioner's case that he had received a notice dated 16 November 2023 under section 142(1) of the Income Tax Act 1961, hereinafter referred to the said act for the assessment year 2015, 2016, after almost 10 years from the date of the assessment. Subsequently, from the date of assessment. Poster. Although the petitioner had duly responded to said notice, to the petitioner's surprise, to responded to the said notice, to the petitioner's surprise, a show cause dated 8th of March 2024 was issued, calling upon the petitioner, seeking explanation from the petitioner as regards cash deposits made by him for a sum of rupees, as regards cash deposit of rupees 6028,770 in the 3 bank accounts of the petitioner during the financial years 2014-15 relating for 14-15, treating the same deposits as income under section 69A of the said act. Since at the relevant point of time, the petitioner was stationed at Saudi Arabia, he had filed his reply through e-proceedings, proceedings, inverted comma, within inverted comma, purota, on 8th of March 2023, and had also sought for an adjournment till the end of March 2024 for him to comply with the notice dated, for him to comply with the said notice posted. At his instance, the department had adjourned the proceedings by issuing a notice dated 11th of March 2024, which is at page 66 of the writ application. Full stop. By such notice, the petitioner was informed that the next date of hearing is fixed on 15th of March 2024 at 11 a.m. Mr. Sultan, learned advocate representing the petitioner, submits that although in terms of the aforesaid notice, the petitioner was required to place his case on the adjourned date, however, to the petitioner's utter surprise, on 14th of March 2023, the petitioner received an email communication with the attachment, not actor beshi ache na. Where is that page? Email communication with two attachments.
Focus notice, the previous focus notice, first is the draft order, then the previous focus notice.
Which two several attachments, one being the show cause notice dated 8th March 2024 and the draft order purportedly dated 15th March 2024. The petitioner submits that even without affording opportunity to the petitioner to respond on the adjourned date, the draft order had been prepared. Full stop. The aforesaid constitutes failure of justice. Apart from the aforesaid constitutes failure of justice, and on the said ground alone, the same should be set aside. Full stop. Mr. Rai, learned advocate representing the respondents, confirms the fact that the notice by notice dated 11th of March 2024, the hearing of the matter was adjourned and fixed on 15th March 2024 at 11 a.m. Having regard to the aforesaid and without going into the other issues raised in the writ application, I am of the view that if the aforesaid draft order passed under section 144C of the said Act, 144C1 of the said Act is set aside by permitting the petitioner a further opportunity to represent its by permitting the petitioner a further opportunity to respond, to present its case. I am of the view. Present its case, then the authorities can, on the basis of the representation made by the petitioner and by taking into consideration the same, pass a fresh draft order. It shall then be open to the petitioner to either accept the same or to raise objection in terms of the provisions contained in section 144C of the said Act before the dispute resolution panel. So, in view thereof, I set aside the order dated 15th of March 2024 and direct the respondent number. Who is the concerned respondent number? Respondent number, no, Mr. Rai. Respondent number 3. And direct the respondent number 3 to fix a date of hearing, fix a date of hearing and to communicate the same to the petitioner. Communicate the same to the petitioner. How is it done? Communication? Communicate the same to the petitioner. Full stop. communicate the same to the petitioner. Full stop. If however the petitioner does not respond to such communication, the communicate the same to the petitioner and to pass the final order and to pass and draft order in terms of section 144 C1 of the said act. Full stop. It is made clear that if the petitioner does not respond to the said communication, the respondent number 3, it shall be open to the respondent number 3 to take appropriate steps as are permissible in law. With the above observations, the writ application stands disposed of.
Lord, kindly fix the time frame, my lord, because
Yes.
why, my lord? Because, my lord, on 30.
It is made clear.
On 31st March, my lord.
It is made clear that the aforesaid writ application has been allowed on the short point without going on to the other questions, and it shall be open to the petitioner to raise all questions before the appropriate authority, if so advised. Full stop. Since no affidavit in opposition has been used, the allegations made in the petition are deemed to have been denied, are deemed not to have been admitted,
But only one request, my lord. Your lordship will kindly fix a time frame within which, my lord, this exercise will be completed.
I direct the respondent number 3.
Even 10 years is what
Court can do it.
I know.
Okay, fix a date of your hearing, preferably within 3 weeks from the date of communication of this order, as preferable.
Yes, my lord, because
I do not know how is he placed. Preferably within a period of 3 weeks from the date of communication of this order, and to communicate the same to the petitioner. And communicate the same to the petitioner, and then to pass off a draft order. No. Communicate the same to the petitioner, and on the basis of the representation to be made by the petitioner or Balaj for the facet also.
grateful.
Yes.
Item number 6.
Yes.
No, we are challenging the order passed under section 148 AD, passed on 29 March 2024, my lord. On the ground, there is a violation of principle of natural justice. Why, my lord? They have issued the 148 AB notice. This is a show cause notice under section 148A, my lord. In response to the notice, I have filed a reply whereby I stated I have asked for the time to file the reply. Again, my lord, they have issued the notice asking me to file a reply within 2 days. But I could not file a reply. I have asked for the adjournment. They have passed on 29 March 2023
When
without
was the first notice issued?
on 11 February 13 February 2024. Man.
You got enough time.
Yes, 13
Yes, sir, I
February
have got
notice was
enough
issued,
time.
my lord. And
I have asked for the time to file a reply, my lord. I am old lady, man. I have asked for the 2 times, my lord, adjournment, my lord. This is my lord. They have passed the order without considering my adjournment letter, my lord. This is short and substance, madam. Kindly see.
opportunity of hearing was given. If your lordship
148
kindly see page number 30 of the order.
Page 29, this is a impugned order. Kindly come to page 30 only. Only 2 paragraphs. Man.
Yes.
Well, I am reading from the middle. In response to the show cause notice dated 13 February 2024, SSC did not file any response within the stipulated time, nor file till date. It is therefore the evident SSC has no explanation to offer in this regard. Had the SSC been any proper explanation, it would definitely have submitted it before the department.
You did not take into consideration his adjournment application.
Yes,
Where are
sir.
the adjournment
I
applications?
have my application, my lord. Kindly.
The prior paragraph, lordship will kindly have a read. My lord. Twice adjournment was given, my lord.
27,
It's
my
not
lord.
that, my lord. It's not been considered, my lord. Again,
26, my lord.
lordship will kindly have a look this paragraph, my lord.
Yes.
My lord, kindly come to page 25, my lord.
Yes.
25 is a e-response form, my lord, the acknowledgement. So kindly see the top of the acknowledgement number. Last 6 digit. That is 21st February 2024. We have submitted response. Record page 25, my lord. 25 of the repetition.
Last 6 digits.
Last 6 digit. Acknowledgement number last 6 digits.
21st February 2024. Yes.
My lord. So we have said, well, kindly grant me a short adjournment. That is when in the remarks part, one kindly come to left side remark, the hash value of remarks. Then open remarks, only remarks. The kindly grant me a short adjournment.
Yes.
Again, my lord, I have filed a reply on page 26, my lord. On 23rd of March 2024. Well, kindly this is the top of the acknowledgement number, last 6 digits. 230324.
He granted you a short
Yes,
adjournment.
well, I have appointed a new person. The second adjournment, they have not considered at all, my lord. I have appointed a new person to look after the said matter. In question, I have already handed over the document. So
Why
that
will a
reply,
further opportunity be given to you?
my lord, I have to give them, they have initiated reassessment proceeding under section 148, my lord. They have to reassess my, kindly see the
Assessment.
reassessment, 148A, my lord.
But why it has been done, Lord? He has purchased a property, he has not filed any return. He has purchased a property worth 57 lakhs, my Lord. That was not shown in the return.
I have
That's
to
why
meet, I have to
assessment
give the
proceeding was
reply.
initiated.
I
And it
get
is,
to
this
get
is
the
not an
opportunity
assessment
to file
stage,
the
my Lord.
reply.
He very well participate in the proceedings, not an
I have
assessment, my Lord. He may participate in the assessment and he file all his objections in the assessment proceedings.
So
not
kindly
assessment
see the
proceedings.
148 note.
Yes, sir, 148 AD
148
order.
capital A, man.
A, B. What
A,
is
B,
it?
my lord. A is the first they have to make an inquiry. They have to issue the 148 AA notice first. In the present case, they have not issued any 148 AA notice.
What is your defense?
And 148,
What is your defense?
my lord, this is a purchase property. I have purchased the property. I have paid only 8 lakhs rupees. But they are saying there is, my lord, there is a provision, section 50C and 56, subsection 2.
Why didn't you
If
file a
this-
reply?
I have to file a
Why did
reply.
you not file a reply?
Well, I have to categorically submit the proper
Reply
reply.
is ready?
Yes, man, ready. Kindly give 2 days time. I will file my reply.
I'm sending it back.
Well, he's an old lady. He could not understand how
My Lord, if your
to
Lordship
give
will
the
kindly
reply
see
to
this
the
prayer aim, my Lord. He has
notice.
challenged the virus of a provision, my Lord. How can he
Forget
challenge
it. I will record that he is not insisting for that.
Sir.
prayer. The present writ application has been filed inter alia, questioning, incidentally challenging the order dated 29th March 2024 issued under section 148A, capital A within bracket D of the Income Tax Act 1961, herein after referred to the said act. Order dated বলেছি?
দিতে তো হবে তোকে লিখে দিতে হবে কেন ঠিক আছে বলে দিই আরে বলতে তো হবে দিতে তো হবে জিনিসটা দিতে চলবে
The petitioner claims to be, how old are you?
বাস
But,
60 years old.
60 years.
Certificate has not been signed, sir. Where is the signature we have at the bottom of the certificate? You have prepared a stamped certificate, but you do not bother to sign the certificate.
এখানে সাইন next one
Who is this advocate?
advocate record my
So you do not, was it read over and explained? Was it read over and explained? Yes or no? But he did not sign it. Why did you not sign it?
I tender my unconditional.
The petitioner cannot read or write in English.
yes he can't she can't madam she can't read it.
The petitioner claims to be a senior citizen and an income tax assessee. Full stop. On or about, it is a petitioner's case that on or about 13th February, now it's the petitioner's case that the petitioner was served with a show cause notice issued under section, show cause notice dated 13th February 2024, issued under section 148, capital A within bracket B of the said act, again said act of the said act, in respect of the assessment year 2020-2021, and was directed to file his reply on or before 21st February 2024. The petitioner contends that Mr. Mojumdar, learned advocate, representing the petitioner by drawing attention of this court to several communications, two several e-proceeding response acknowledgements dated 21st of February 2024 and 12th of March 2024 that the petitioner had sought for
23rd of March. Second.
3rd of March 2024 that the petitioner had sought for an adjournment, that though the petitioner had sought for an adjournment, the same was declined. No. By drawing attention of this court, drawing attention of this court to the communication date, to the e-proceedings respond acknowledgement dated 21st of February 2024, submits that the petitioner had initially sought for an adjournment which was granted. However, the subsequent adjournment sought for by the petitioner on 23rd March 2024 was completely ignored by the authorities. According to Mr. Mojumdar, the petitioner, being an elderly lady and not being conversant with the affairs, had appointed a person to look after the matter, appointed a new person to look after the matter, and had sought for and for the said purpose had sought for an adjournment. The authorities, however, the respondent number 3,
One, my lord.
respondent number 1, however, by his order dated
29th March.
29th March.
3rd March 2024,
29th March, my lord.
29th March 2024, without taking note of the subsequent e-proceedings response acknowledgement, had passed the order under section 148 AB of the said Act.
A small d.
Small
A
d.
small d.
No, capital A
Capital S, small
Capital A
d.
small d.
of the said Act. Full stop. I find that once full stop, the order, full stop, in the facts as stated here in our, it is submitted that in the facts as stated here in our, it is submitted that this honorable court may be pleased to set aside the aforesaid order and provide one further opportunity to petitioner to provide a further opportunity to petitioner to place its case before the respondent number 1. Respondent number 1. Full stop. We learned advocate representing respondents on the other hand submits that the petitioner was duly given an opportunity to respond. Now, duly given. The petitioner was duly served with a notice under section 148 capital A within brackets B of the said Act. Although the petitioner was required to give his response along with supporting documents on or 21st February 2024, the petitioner, instead of filing such response, had sought for an adjournment on the said date.
Which was granted.
Subsequently, again on
11th March.
Subsequently, again on 23rd of March 2024, a further adjournment was sought for. Yes, sir.
So only he's saying, my lord, the 11th of March, another notice was
11th of
issued.
March, another notice was issued asking, my lord, that is there, my lord.
Page 27, I think, my lord.
My lord, in page 30, my lord, in the ordering portion, you will see that's
No, no, my
recorded.
lord is,
Where is that notice?
my lord, kindly come to page
No, no, wait,
27,
where
one.
is that notice?
27. Page 27.
You will know? We last night again. Adjournment of the said day, full stop. At the instance of the petitioner, the matter was adjourned and by notice dated 11th of March 2024. Further hearing was fixed on 13th of March 2024.
Yes.
Full stop. The petitioner did not file any response
On
on
30th.
the said date.
Yes. On 23rd, he has said, but
And accordingly, as on the said date, to say it is in such circumstances, the final order dated 29th March 2024 had been passed. There is no irregularity on the part of the respondents in passing the final order. That is it.
yes,
Heard the learned advocates appearing for the respective parties and considered the materials on record. Full stop. In the case, I notice that a notice under section 148, capital A within bracket B of the said act has been issued, calling upon the petitioner to respond on 21st February 2024. Full stop. Admittedly, the petitioner had sought for an adjournment on the said date. Full stop. At the instance of the petitioner, the respondents had subsequently issued a notice dated 11th March 2024 intimating that the next date for hearing was fixed on 13th of March 2024. Full stop. It is true that the petitioner did not file any adjournment on the said date. However, did not take any steps on the said date. However, the respondents also did not pass any order.
Yeah.
Pass any order on the said date.
Yes.
Full stop. The record reveals that before the matter was finally disposed of, the petitioner had, before the matter could be finally disposed of, the petitioner had sought for an adjournment on the grounds, had sought for an adjournment
Page 26.
of the proceedings by e-proceedings response through the e-proceedings on 23rd of March 2024. Such fact would corroborate from the document, from the acknowledgement, which is at page 26 of the petition. Full stop. Once such application was filed before the authorities, authorities, in my view, was obliged to consider the same. Full stop. There is no reflection of the aforesaid. Adjournment sought for by the petitioner in the final order passed by the respondents. Also, having regard to the aforesaid, I am of the view that the aforesaid order cannot oblige. There is no reflection. I am of the view that the final order cannot be sustained once the petitioner had applied for adjournment. It was for the respondents to take a decision thereon. Full stop. Since take a decision thereon and to intimate the same to the petitioner. Full stop. Full stop. The final order dated the order dated 29 March 2024 is accordingly set aside and quashed. Full stop. The petitioner, however, shall however, be at liberty to file its response to the aforesaid response to the original show cause notice dated 13th of February 2024 within a period of 7 days from the date of communication of this order. Full stop. If such response is filed with the respondent number 1, only response. The response is filed. It's no personal hearing.
No, if he asks for personally, then he has to give. As per the provisions of the Act, he has to file a reply. In the reply, you can ask for the personal reply. If you don't ask, then they will not obliged to give it.
By the petitioner with the respondent number 1. And in case personal hearing is sought for, the respondent number 1 shall deal with the same and dispose of the response to the show cause by giving personal hearing if necessary, by giving a personal hearing to the petitioner and or its representative with the above in the event the petitioner does not file its response within the period indicated herein above, the respondent number 1, it shall be open to the respondent number 1 to take steps in accordance with.
it should be passed as stipulated within a period of short. We can indicate the period.
That's provided for that.
But, they will file within 1 week and we'll dispose of our pass a fresh order within a period of 2 or 3
If
weeks.
he
That
asks
will
for
kindly.
personal hearing, there he
otherwise
has to give the
The
person.
entire proceeding has to be done within a.
The entire process should be completed within a 3 weeks from date.
4 weeks.
4 weeks from date.
তোমার চাওয়া উচিত, আমি
Since-
চাইছি।
Since no, it is no opposition.
Since the allegation were, my lord, no affidavit.
I'm not.
Affidavit is filed. Yes.
Next কিছু
Disclose.
আমি যাই না।
Your Lordship, item number 7 to 11 are same matters pertaining to pension.
Yes, madam.
Your Lordship, all accounts have been connected with the Aadhaar cards of the workmen. It will take another fortnight's time that the amount will be remitted in the.
Hold on, madam, kindly wait. Let me call on, yes, ডাকো। না না এটাকে ডাকো আগে, তারপরটা ডাকো। এটাকে ডাকো আগে, এটা এই যে।
Item number 7, Lord, I am for the petitioner.
I am for the Provident Fund Authority.
Lord, what happened, Lord? After passing of the order, 2nd of April 2024, Lord, order, the company called for the petitioner, Lord, for some clarification for some documents, Lord. They went to the opposite company office, Lord. When they meet the dealing officer of the pension officer, Lord, they demanded 2,000 per each, Lord, and withdraw the case, and 6 months.
What is this
deducted
going
from
on,
pension.
madam?
Lord,
With us, Your Lordship, he's saying about pension authorities.
Lord,
It has been linked. Amount is being remitted in his account.
Madam, who is asking, demanding money?
Lord, Delta factory, my lord.
Delta company.
Delta
No,
company.
no.
Demanding.
Yes, my lord.
Madam, I'll ensure everyone stands in court here.
My lord,
What is this going on? You demand money?
all the
No, Your Lordship.
To withdraw the petition? Yes,
But
madam, you are here.
Lordship, I don't have.
This is a very serious allegation. What is this going on?
last 2 occasions they paid for adjournment, my lord.
Why would we demand money from them for pension, Your Lordship? They have made this complaint before the
They
PA
can make it.
prosecutors.
How can we, they can make any complaint. Your
You
Lordship.
want demanding? I do not know what is happening.
Why would we demand money for pension?
Very well. What happened to what happened to the communication? What happened to the steps taken by you?
We are taking steps for uploading the Aadhaar.
Or that you are demanding money?
We are not demanding money. I had given instructions that kindly issue notices to all trade unions because it is their duty to get their workers come and get it linked. There cannot be any question of demanding money. That is my statutory duty. Why would I demand money for that, Your Lordship?
You are not complying with any of your duties, madam. Forget your statutory duty.
But it is not obligation that I am submitting that if I have not complied with my obligation, Your Lordship, they can very well submit in form.
So they will go on making complaints.
Before the magistrate.
So you want them to go before the magistrate now? The court is hearing the matter. I can take cognizance of this.
Linking it, we are not demanding any money.
How soon will you complete the entire process?
Your Lordship, I have instruction. It will take fortnight for the amount to be remitted in his account. The pension amount which he is to receive, other than item number 9, his details could not be located. Rest of them, it has been connected, and within fortnight, amount will be remitted.
They are not updating the contribution since 2018.
Miss Pandey, learned advocate. Anamika Pandey, learned advocate, representing the respondent numbers 3 and 4 on instructions submits that except for the petitioner, what is the name of the petitioner? 9? Now, আলাদা order. So ওইটাতে শুধু হবে, except নয়. Submits that Form 10D has already been submitted with the Provident Fund authorities.
No, my lord, we have not received any complaint.
She is saying so.
No, my lord.
Pension authorities, not Provident Fund, pension authorities.
Same.
These are pertaining to pension.
Anything.
Form
Provident-
10D, did you receive?
No.
Your Lordship, from bank, it has been connected, Your Lordship.
No. Form 10D has to be submitted.
Your Lordship, first his Aadhaar and bank account has to be linked.
So those formalities, madam, you kindly do. I do not know what you will do. Please ensure that this is done. Don't
Your Lordship,
to court and tell me this is to be done, the other thing is not completed. Whatever is required to be completed, you will get it completed.
Your Lordship, they have submitted their Aadhaar
Can you get it done?
within a fortnight, Your Lordship. Kindly keep it in the monthly list of May. Everything will be done.
Appearing for the respondent numbers 3 and 4 submits that the entire process as regards submission of Form 10D
And other
and
formalities,
other formalities in connection with disbursal of pension in favor of the petitioner shall be completed within a period of fortnight. In view thereof, she prays for an accommodation. Having regard in view thereof, she prays for an accommodation. Full stop. Having regard to the aforesaid, let this matter stand adjourned and appear in the monthly list of May 2024. And non-number on appearing for the respondent numbers 3 and 4 submits that the details of the petition are yet to be located. As such, she prays for an accommodation to take steps in the matter. In view thereof, adjourned.
Your Lordship, petitioner advocate could supply the entire Aadhaar card and Form D, signed Form D.
Yes, Mr. Khan, supply her with copies.
I will take
I'm not
instructions.
recording that.
Really unfortunate if maybe at worker level they have done it, but the head office has no instructions of these sorts, nothing. I just spoke to them today and yesterday.
Madam, sitting in the helm, madam, you don't realize how difficulty these persons may be facing. Yes. Call the next matter at 12, fix at 12, supplementary list, accepting 9 for different order. Yes. Call the supplementary list.
Supplemental list, fixed matter.
Supplementary list matter, my lord, I am completely handicapped because had I been given the prior notice, then I would have brought the copy of the writ petition because this is not running a lordship's list today. I am completely handicapped.
They are not at fault.
But they could have, my lord, sent a
They are not at fault.
No, it
was not listed by the court.
They could have, my lord, sent a notice, mail me a notice yesterday saying that they are going to mention the matter to before lordship for the matter to be taken up by your lordship today. I would have brought the.
Today I was not aware that your lordship will direct it to be taken up today. So I could.
Oh, you didn't expect that.
I did not expect that your lordship will.
No, if it is because of court's fault, then certainly.
No, not court's fault. Not court's fault. Not at all. Your lordship is kind enough to accommodate me to.
Until it goes tomorrow.
No, my lord,
Tomorrow I don't take up.
No, my lord, only thing, my lord, it is a matter which is a covered matter by judgment of this Honorable High Court, several other High Courts. The issue.
Special urgency is there.
My lord,
What urgency is there?
my lord,
I'll record his submission. He prays for an accommodation. Don't take any steps, coercive steps.
No, there is no court. No, courtship is, there is no courtship is a question of courtship is.
In month of
My lord, can your lordship keep it tomorrow, my lord?
Tomorrow, the other matters are.
My lord, one matter, if your lordship can
If
accommodate.
I make an exception for you, then I have to make an exception for everyone. Why not the other matters? Tell me, sir.
Yes, my lord.
If I make an exception for you, why not the other matters?
I ask if my learned friend can. If
Can
your
it not wait? It is so urgent. Tell me this. Tell me this. Can it not wait?
okay, my lord, then let it keep.
Even in May, I'll be taking up all the matters.
On the list.
The learned advocate representing the state respondents.
Don't send it to monthly list, my lord. Then I don't know whether it.
Because my lord will be sitting in the month.
Or taking the monthly list first, I
Take
don't.
up the monthly list.
Will lordship may kindly keeps it on a specific date in the month of May, so that my learned friend.
Your matter will be taken up. Motions we are given priority. Every day motions will be taken up to Thursday. Till such time, I'm in a position to see how many motions are there. After the vacation, I'll be taking up all the motions, irrespective of whether they are mentioned or not. I have given some breather for the time being. I do not know why the people are not mentioning. But nobody had come and mentioned the matters.
Because your lordship allows only mentioning on Mondays. That is.
But still there, on Monday, nobody mentioned. Anyway, in view thereof, this Tirupati assets.
Yes, my lord.
This is Tirupati assets.
Tirupati assets. My lord, their registration has been cancelled. They have.
No, I'm not on that.
Right.
Rungtas? No.
No.
Since an accommodation has been sought for on behalf of the respondents, let this matter stand adjourned and appear in the mark list.
On this.
Great.
I'm grateful, my lord.
And I ought not to have listed this.
I tender my apology because.
No, I'm not on that. Petitioner did not expect it. Should be.
Extremely grateful.
No, once you, my question is, once you give a date, That should appear. There is no necessity for mentioning that. It will automatically appear in. That should appear in the list. So otherwise, if you file it, then you come and mention, then what is the use of providing a date in the presentation form? Whichever date you provide, it should appear on that date
Appeared today.
or on the next date, available date. Provide on a Sunday, it will appear on the next available date. After the from the month of May, that procedure will be followed.
On the returnable date, the matters will.
Yeah, and all matters will appear in the returnable date. If it does not appear, please mention the matters.
Get it. Release item number 12.
I'm for the respondent. My lord, today, my lord, I am seeking your lordships, my lord. My lord, we want to file one affidavit. My lord, my lord, something has been fraud by the petitioner. I will place, my lord, on record, my lord, by filing, my lord, one-page affidavit. My lord, we have found, my lord, something from the records, my lord, that something has
What
been
is
fraud.
that? Tell me.
My
What
lord,
is the matter?
some, my lord, annexure has been, my lord, some document has been annexed. My lord, the totally contents, my lord, has been changed.
The matter relates to my lord, regularization of the service of the petitioner, my lord. Well, kindly remember.
I remember your matter.
Yes, my lord. That matter, my lord, the post of stenographer, she is working from 1998. Mr. Mojumdar submitted, my lord, that are good for the petitioner, my lord. And one similar situated employee's matter went to the division bench. It was submission made on the on behalf of the respondents that matter should be dealt with in accordance with the order of the division bench. That is the reason, my lord, your lordship was on 3rd of March, possibly, my lord, passed a direction to keep all the files together, along with the state has been directed.
Yes.
My lord, on the basis of
Where are the records?
Your Lordship, we still haven't received the full records, Your Lordship. Mr. Jayanta Shamanta appears in this matter, but Your Lordship, we still haven't received the complete records, Your Lordship. Some documents are still missing. We are trying to get them. Kindly grant us some more time, Your Lordship.
Learned advocate since Miss Banerjee. You are Miss Banerjee?
Yes, Your Lordship.
Since Miss Banerjee, learned advocate representing the state, prays for an accommodation on the ground that prays for appearing for the state submits that she submits that the records are still not available. The records still could not be. Why is it not available?
Your Lordship, we have received some of the documents, a few documents that are from 1999. We still haven't received clear copies, Your Lordship. We are waiting on that. Once we receive the clear legible copies, we will submit it before the court.
Submits that having regard to submits that she needs some more time to place the records of this case before this court. According to her, since the records are old, since these are old records, they are not readily available, and as such, on such ground, the accommodation is sought for. Having said, let this matter stand adjourned and appear.
It was on civil location.
এই documents
না জুন মাসে দিন
original engineers.
জুন মাসে বলে
Let it be on me, my lord.
Not possible. Before that, motions will be there. You want it to be there, it will be staying there in the list, nothing, no effective. Supplementary list, I have to call. I'll place it in monthly list in that case.
Monthly list of May, my lord.
If you want, I can place it in monthly list or June supplementary list, whichever you want. 2010, it can also reach.
No. In that event, my lord, I shall.
It can also reach 2010 matter. May monthly list.
No, my lord. I am placing for June supplementary list.
June একটা supplementary বৃহস্পতিবার থেকে দিয়ে দাও 13th of June.
My lord, in the meantime, affidavit maybe, my lord.
No, I did not grant affidavit.
My lord, I can show your lordship right now, my lord. What is
on the next occasion, show me. If I'm satisfied, then only I'll grant you leave. You bring the records.
My lord. My lord, records with me. My lord, some records, what
Look
I,
into those records, Mr. Vishwas. Why will I not look into the records? Even when affidavit is not filed, I permit respondents to place records and I accept the records. Records are there. What is the difficulty?
I have,
If he has brought in any document which according to you has been interpolated, then consequence will follow. From the record, I can understand. You don't have to identify.
very well.
You can say it is interpolated.
My lord, very well.
The moment you say, I will accept it, the original document has to be there.
Yes, yes.
In absence of original
No, no,
document, by
definitely.
an affidavit, you cannot improve your case.
আমার আমার আমাদের
Item number 13.
Item number 13, Mr. Shamit Chatterjee is appearing virtually.
May I please, my lord? Item number 13, I beg to appear for the petitioner. This is that matter, my lord, wherein your lordship has been pleased enough to grant them an opportunity to file a report so far as the vacancy is concerned, my lord. But this matter, my lord, the petition, but they have served us.
Yes.
But
You
they
are-
have served us.
The position will not permit his reservation is not possible. Why? Where was he placed?
He
In
was
which position?
he is an OBC candidate, my lord.
But
We
the
have
issue, my lord, may I submit one thing?
Wait.
My lord.
but we have requested for 5 posts, my lord. My lord, it is pending at the request stage before the headquarters, my lord. Even the sanction has not been granted till now, my lord. And even if it is granted, my lord, OBC candidate, it's not the vacancy for OBC candidate, my lord, is not arising at this moment, my lord. Out of these 5.
But the issue is, my lord, in the advertisement, my lord, which is at page 47, my lord, nothing was specified as to what is the disability or what is required.
You are an OBC candidate, sir. Yes or
My
no?
lord, absolutely, my lord. I bow down, my lord. But the interim order was passed on that basis because they had played fraud on this court.
Where is the interim order?
My lord, 2nd of December 2016, my lord. My lord, wherein the Honorable Coordinate Bench has recorded their fraud. And for that basis, my lord, the order was passed.
Where is the order? Dated?
My lord, 2nd of December 2016. Justice Talukdar's orders, my lord. There was total misrepresentation and fraud played on this court, and for which, my lord, the Honorable Justice Talukdar was pleased enough to grant an interim order that one post has to be vacant and the person who is working in his place shall be subject to the result of this writ petition. I was provisionally selected. And by mail, my lord, they had intimated that I have to go for a further medical checkup, wherein my disability was detected of 20%.
These circumstances relating to grant of an interim relief in favor, interim protection in favor of the petitioner would more fully appear from the order dated 2nd of December 2016, which is extracted herein. 2nd of December 2016, passed by a coordinate bench of this court, which is extracted herein. Poor order that's it. Unfortunately,
The more interesting is when a general category has been placed in OBC, who was working. Thereafter, he expired. And then another person has been, Dhaniram has been in place, who is not now working.
Unfortunately, the writ application was dismissed by an order dated 7th of November 2019. Was dismissed for default by an order dated 7th of November 2019. Full stop. By an order dated 19th of May 2022. Now, on a restoration application being filed,
And all in 2020, my lord.
which was registered as CAN 7 of 2020, a coordinate bench of this court by an order dated 19th of May 2022 while restoring the application, while restoring the writ application, being WPA 10104 of 2014, by recalling the order dated 7th of November 2019,
But we were restrained due to the COVID restraints, my lord.
that in the given facts, since the given facts do not permit extension or reinstatement of the interim order, had directed exchange of affidavits in CAN 6 of 2020 for the purpose of assessing whether or not to pass a fresh interim order or to reinstate the order which was continued till dismissal of the writ petition. এই আগের লাইনটা কি হয়েছিল? ঠিক আছে, reinstate. এই আগের লাইন আগে একটা বলেছে extension of the interim. Extension stroke reinstatement বলে দিলাম, সেটা শুধু extension হবে আগের লাইন. Since then, affidavits have been exchanged. Where is your affidavit? CAN 6. ওপরে না, this is an application. ওই ওপরে this is an application. CAN 6 of 2020. This is an application inter alia praying for extension of the interim order passed by a coordinate bench of this court on 2nd December 2016. Where is your opposition?
But we have filed our reply also, my lord.
What have you stated?
But they have stated that But they have stated that the general candidate has been replaced by now Dhaniram, who had died subsequently in the year 2020.
Where is that? Where is that? You did not file it.
Fine.
You keep it in your pocket, Mr. Chatterjee. Mr. Chatterjee, learned advocate, by placing the affidavit in opposition to the aforesaid application, submits that after the writ application was dismissed for default on 7 November 2019, and on the basis of a recruitment advertisement published on, where is this? When was this published?
This was 2020, 4th of November 2020.
Published on
4th of November 2020 at page 9 of the affidavit. Oh, no, this is the death certificate. I'm sorry. My lord, this is at page 10 of the affidavit, my lord.
No.
This is page 10 of the affidavit, my lord. Commences from 7th of November 7th of December 2020, my lord.
Published sometimes in December 2020.
2020.
The post which had been reserved for the petitioner had been filled up after completion of the recruitment process by one Dhoniram by issuing offer of appointment Why is it this particular post? How can I identify, sir? It is this post which was filled up.
My lord, at page 10, my lord, kindly have a look at the
Where is the reference to the order passed by the High Court?
At page 10, my lord, the post is there, my lord, junior engineering assistant to 4, my lord, OBC.
Yes.
OBC. There is only one post, my lord.
And where did the High Court direct you to reserve an OBC post?
Yes, my lord.
When 2nd of December 2016.
OBC post.
That order of Justice Talukdar, my lord.
2nd of December 2016.
By Dhoniram. This is offer of appointment.
My lord.
Dhoniram accepted.
Yes, my lord. The joining is also there on record, my lord.
Where is that acceptance?
Page 22 is the joining, my lord.
By placing before this court the joining report of Dhoniram, it is submitted that the said post has already been filled up.
But possibly by compulsion appointment he has been appointed.
And it is no longer possible for the respondents to reserve the said post. Yes, sir, this was by compassionate appointment.
Doesn't appear from the offer of appointment.
I'm asking you.
No, my lord.
I will record your submission on this.
Because
I will record your submission on this.
Yes, because this is pursuant to the open
Mr. Chatterjee, in response to the query made by the court, submits that the aforesaid appointment was as per regular recruitment and did not concern compassionate appointment. Yes. So I am going to grant the decline relief to a particular person. So your stand must be clear.
I have not stated that this is a compulsory appointment on.
I've recorded your response.
Yes.
Yes. Now, this post is still occupied by him.
Yes. Yes, ma'am.
Kindly appreciates that during the COVID times, we could not mention the matter because only urgent matter were taken.
Prior to COVID, sir. Dismissed prior to COVID,
No,
2000.
absolutely, my lord.
You don't have any.
After March, my lord.
Sorry, sir, you don't have any explanation.
But after March, my lord, things. But we had filed in October 2020.
Where is your reply?
But we had filed our reply, my lord. On 8th of February, my lord, 2022.
What have you said?
But we have denied all allegations made in the opposition by the IOCL. And we have also taken the point that the first appointment of Yogbir Singh, but that was fraud, which the Honorable Court had.
Is there? Where have you stated?
After the expiry, when this post became vacant, my lord, thereafter the petition was dismissed, we filled it up, my lord. Too.
No, he says Yogbir Singh.
Yes, my lord. In division bench, my lord, before the Honorable Division Bench, but they have stated that Yogbir Singh is the person who is working in that post. Now, my lord, before the Honorable Single Bench, my lord, it was detected that Yogbir Singh is a general category who has been placed in the OBC category and he is working. The order dated 2nd of December 2016 is very vital, my lord. But before the Honorable Division Bench, but it was recorded.
This order was Talukdar after the division bench, man.
Yes, my lord.
Subsequently, the post was kept vacant for the petition.
In 2020, Yogbir Singh died. But his counsel was also appearing in 22 when the matter was restored.
Mr. Chatterjee,
My lord.
advocate representing the petitioner, submits that what was notified by the respondents.
Yes, in the advertisement. Page 47.
In the advertisement.
But if your lordship sees the minimal. My lord,
what is this going on?
My lord, I apologize, my lord.
In the recruitment advertisement published in December 2022, against the post of junior engineer assistant 4, fire and safety, OBC, reserved for OBC candidate, was the post which fell vacant on the death of one Yagyavr Singh, who belonged to the unreserved category. Yes, Yogbir Singh died.
Yogbir Singh was there in service in 2016. In 2016 itself, Justice Talukdar kept one post vacant. So what connection does Yogbir Singh has with this?
And why did you indicate in this page number?
If your lordship kindly sees the division bench order.
I Wait. Yes, where is the division bench order?
But 7th of April 2015.
Where have you annexed that?
But it is in the paperwork alert itself.
এই পেপার বই আছে কোনো? দেখি দাও। You have a division bench order separately?
Yes, ma'am.
Give it to me. দাও না এখানে থেকে দাও না।
2015.
Yes.
The last paragraph, my lord. Last second paragraph. My lord. But the Honorable Division Bench, my lord, it is the IOCL who had placed it on record before the Honorable Division Bench that Yogveer Singh is working. And on that virtue, my lord, the Honorable Division Bench was pleased enough to direct the Honorable Single Bench to add him as a party and then proceed with the matter after filing of affidavits.
হ্যাঁ
But
কি
it
বল?
was-
Such fact would corroborate from the disclosure made by the Indian Oil Corporation in their affidavit where did they disclose this? Where is the affidavit? Which page?
But the order of this.
Order I have seen. Order records there is a disclosure made in the affidavit. Where is that
Yes, my lord,
affidavit?
on the basis of the affidavit that was recorded in the order itself, my lord. 2nd of December
Go
2016.
through that. I do not need to go through the affidavit.
Absolutely, my lord. I bowed down.
Where is that affidavit?
My
Where
lord, I'm
is
showing you.
was the affidavit disclosed before the division bench? Yes, sir. Was it disclosed before the division bench?
The affidavit, my lord, has been filed before the single bench on 10th of December 2015.
Mr. Chatterjee, division bench records an order. Records in the order, it records that you have made this disclosure by way of an affidavit
My lord.
lately. So it is before the division bench.
Yes.
Where is that affidavit?
This is. I have it with me, my lord. I have it with me.
Which page? Tell me.
This is not the division. This is
Oh,
the
please take it,
compilation
take
of-
it দাও ওটা দাও আরে দেখো ওটা দাও
2015 compilation of documents.
কি বললো such fact and is also reflected in the order passed by the division bench of this court on
7th of April 2015.
7th April 2015. I find that in the supplementary affidavit filed on behalf of the respondent number 2, in paragraph 5 thereof, the respondent number 2 has claimed since the petitioner as an OBC candidate secured better marks than Jogvinder Singh, he was treated as an unreserved candidate. since the petitioner was found medically unfit, his candidature for employment in the corporation was cancelled and Yogender Singh was offered employment for the post of JEA 4 Fire and Safety, which was accepted, and he joined the service of the corporation from 21st of October 2013. To more fully appreciate the same, the aforesaid statement made by the respondent number 2 in paragraph 5 of the supplementary affidavit affirmed on 10th December 2015 is extracted herein below. Having regard to the aforesaid, I find that if the respondents, having treated a reserved category post to be an unreserved category post and having offered the same to an unreserved category person, cannot be permitted to defeat the interim order passed by this court by taking shelter of the fact that the said post, which was treated to be an unreserved category, on the death of this, unreserved category, and was fraudulently filled up, fraudulently, unreserved category, on the death of the person holding the post, কি বললাম, সরি এখানটা গুলিয়ে গেল, হ্যাঁ, interim order passed by this court, ওই অবধি থাক, full stop. But না, ওইটুকুনি, full stop. Since the respondents have already treated a post, a reserved category post, as an unreserved category, the defense set up by the respondents where have you stated you are following on one model? Where is that line of yours? Paragraph?
Paragraph 7.
Yes. Where is that line? No, one presidential model is stated. Where is that? I read this just now.
Paragraph 7 of the affidavit I filed today, the thinner one.
Paragraph 7, today.
Yes.
Yes, place it.
That the IOCL Haldia Refinery has been following the reservation roster as per the presidential directives on reservation.
Where are you reading? Paragraph 7.
Page 3, paragraph 7.
Page 3. এটাই তো নাকি affidavit of
Not that one, my lord, the other, the thinner affidavit, my lord, as per your lordship last direction.
Oh, yes. Correct. As such, the defense set up by the respondents that they have been strictly following the reservation roster as per the presidential directive on reservation cannot be accepted, Full stop. The respondents having themselves deviated therefrom cannot be permitted to fall back on the said presidential directive on reservation so as to defeat an interim order passed by this court.
I make one submission, my lord.
Presidential directive on reservation so as to defeat the interim order passed by this court. In view thereof, full stop, passed by this court, full stop. This court, by an order dated 3rd April 2024, had directed the respondents, taking note of the submissions made by the respondents, now, had the 20th April 20th March 2024, taking note of the submissions made by the learned advocate representing the respondent number 2, that they had requested respondent number 2, that the respondent number 2 had requested the competent authority to sanction 5 number of vacancies in the post of junior engineering assistant -4 fire and service, had directed the deputy general manager HR of the respondent number 2 to file an affidavit disclosing the steps taken by the respondents for seeking sanction of 5 number of vacancies in the post of junior engineering assistant (4) fire and services, including particulars of vacancies in respect whereof sanction has been sought for. Full stop. Pursuant to the aforesaid, an affidavit has been filed in court today. From such affidavit, it would appear that in terms of the request for sanction, কি বলছো? Has been filed. Full stop. Full stop. In paragraph 5 of the said affidavit, the respondents have stated as follows. Set out. Full stop. Having regard to the disclosure made by the respondents, I am of the view that in the event the aforesaid sanction is made, the respondent shall retain 1 post of junior engineer assistant 4 fire and services from the reserved category vacant. Now, reserved category, be it from the reserved stroke unreserved category.
But he can only be treated as unreserved if he gets more marks than the unreserved category.
But I scored the highest. That only because of the disability I was deselected.
In an unreserved category, sir, after you refuse to give him.
But he still remains reserved category. He was appointed in unreserved because he got more marks.
But kindly appreciates, my lord.
His status as a reserved category does not change, my lord.
Change the rule of the game, my lord. After I was provisionally selected.
No, I order to high the order to 2nd December. 16. One post of the vacant until further notice.
But the interim order was in the OBC category, my lord. That is what he is praying for.
I provided reasons why I directed in the reserved category, unreserved category.
He got more marks. That is why he was treated as that.
And directions. The aforesaid writ application stands disposed of. The aforesaid application stands disposed of. List this matter for final consideration in the monthly list. That's it. Appeal করবে এখন।
If your lordship kindly fix a date, my lord. Any date, my lord. In June, my lord.
A lot will happen before that.
But otherwise, my lord, as stipulated, if that stipulated time is not given, my lord, this will take, my lord. Already more than a decade has passed, my lord. my lord, already a decade has passed. It's only because of your lordship's kindness, my lord, this.
Appeal part paragraph set out for
My lord, only because of your lordship's kindness, my lord, have been gracious enough to grant us this relief, my lord.
all the next matter.
I'm grateful, my lord. Grateful. I'm grateful.
Item number 14.
Yes.
On the last occasion,
How can I give it?
14 and 15. Mr. Ghosh has raised the point of section 279 of the Companies Act. 279. 279, which says the stay of suit, etc., on winding up order.
Have you got
So I
authorities
tried
for this?
level based to get some judgment. Lordship, I candidly submit. Lordship, I could not find any judgment on the.
You did not try.
Lordship,
Have you got any authorities?
Yes.
Yes, see, he's ready with authority.
I must be fair. I must be fair.
Yes.
Although I am appearing for official, I must be fair. My lord, very hard judgment.
Give him the judgments, he'll consider and come back. They are against you and in his favor.
Not against him. 226 will apply. There are 2-3 judgments that 226 for that no leave is required. But in one case,
These are proceedings.
yes, my lord,
This is a proceeding, not a suit.
my lord, I must be.
Let him go through and get ready in the matter. Not like this. I will not dispose of. Not on the basis you can have a piggyback right. Mr. Ghosh, give him the copies
I'm
and
really
share it.
grateful to Mr.
And I'll
Ghosh.
place it on the next after in the monthly list of May.
May.
I'll fix it in sometimes in May.
May I hand over a copy?
Yes,
Because-
yes.
দিচ্ছি ভাই দিচ্ছি আগে এইটা একটা দিচ্ছি এটা আমি দিচ্ছি আপনার এটা লিখুন 120 company cases 465 একটা লিখুন 92 company cases 671 My lord, I have got another judgment unreported perhaps of this court with regard to insolvency and bankruptcy code. Although the issue is something different, but it may be helpful to us. That's why I'm it order.
Yes, number.
আরেকটা লিখুন
This Rajasthan is reported it.
company cases.
Company cases. All these are company cases.
Yes. The next one is not reported or reported.
No, volume 120 company cases.
Yes, both are company
20
cases.
and 92 company cases.
Wait. Okay.
দেখি দাও।
And my lord, another judgment, it may be, my lord, it is based on insolvency and bankruptcy code. There are several judgments considered of the Supreme Court, and ultimately IRP was appointed. IRP status is like that of an official liquidator also. And my lord, one more judgment it may be helpful to some extent.
Yes.
My lord, another judgment with regard to scope of 446, my lord, this is AIR 72 Supreme Court 878. My lord, here I say, my lord, something. My lord, this judgment was based on a provision of 1956, in which there is a provision that the company court, if it wishes, it may transfer any of the proceeding from them. But that provision was subsequently deleted in 1956 Act, and there is no existence of that provision of the new Act also. But even then, it is helpful because with regard to
Place the relevant portion, Mr. Ghosh, kindly.
head note A and
You place it, yes.
paragraph 7, last
Yes.
paragraph 7. The court held that if any proceeding is transferred from any quasi-judicial authority like income tax, it is not possible for the company court to adjudicate. But in my own personal experience, I have seen so many in Industrial Dispute Act with regard to reference. The court always gives permission or sanction to proceed in that suit, in the reference, in the industrial dispute matter for passing award and all these things, because court cannot adjudicate all this. In criminal proceeding, court cannot adjudicate.
But if the court is not powerless, court is not
Yes, court is powerless, but even then, to avoid all this controversy, court always gives permission to proceed in that, to quantify that amount. Come back. Come back. Industrial dispute reference award, the adjudication of claim of workers before the industrial dispute court, industrial tribunal.
Yes.
Well, all these cases, well, in my personal experience also seen that always company court gives leave, go, adjudicate, come back. Because otherwise company court cannot decide all these questions. It is impossible. It is impossible. But
Very well. I'll fix it on
as well, Lordship,
13 June. Heard the learned advocates for the parties list this matter on 13 June.
Well, there are two matters, separate order be passed accordingly.
Separate matters. Orders is combined orders.
Yes.
Same order. It will be recorded, both the matters are.
আপনি পেয়েছেন তো সব?
আমি সাজেশন গুলো নিচ্ছি।
Sir, go through this.
Yes, I'm really grateful to Mr.
No,
Ghosh, my learned friend.
because I should be fair. I am appealing for official legal
certainly.
tender. I should be fair. It's not my money. It's
Not the question of money, question of whatever you submit, I will be accepting the contentions of parties and deciding on that basis.
I should be fair, always appealing for official legal tender. May it be treated as Pathan.
I am retaining jurisdiction. I have. Service matter I am continuing to hear with group 4.
For a considerable period.
Yes, it is there.
We expect this is determination should return with
Permanent service matter makes.
as well as group 3 also.
No, no.
Yes.
Yes, yes. Call the list. আর আছে? দেখো দেখো দেখো
16. 16 matter I am appearing on behalf of the Union of India.
You ready?
Yes. My lord, I am already done by what my learned friend has furnished on the last day. My lord, there were two delinquents. One had preferred a writ petition here. His writ petition dismissed, thereafter appeal preferred. Appeal court allowed him to continue in the service by an interim order. Ultimately,
Dismissed, everything gone.
everything gone. He went up in appeal before the SLP also. That also gone. That also gone. So I am
is also on similar.
will say that I am on the same footing. So my case as on that aspect is almost finished. But I will try to distinguish only 3 small points. I'll indicate if my lord is pleased that his senior may reply.
they may, only three small points. First, my consent, the statement which was taken on consent was on a paper which was written in Hindi. I have no connection or no knowledge about Hindi. I am a Keralite who can speak in English, write in English, and in the native language. I had
In the form 12, what did you disclose? Where is the form 12? You brought the records?
No, it is not here, my lord.
It is not here.
Where are the records?
I have to collect, my lord.
Then
and
give me some time, my lord. I'll bring.
Well, I'll indicate these 2 points, nothing more. They can reply and your lordship will decide. I have to assist
In
your
case of Hindi, my lord, they have got a specific training of 8 weeks where they learn local languages as well as Hindi, my lord.
We can.
You want me to dismiss this petition on the consideration you wanted me to allow it also. If you wanted me to allow the petition on one consideration, on the same consideration, I should dismiss it.
My lord, I would not say that your lordship has pointed out rightly whether affirmation was done or not. I think affirmation was done in Hindi, in English. So on that count also, I do not want to go into that details.
So Hindi is no longer there.
No, Hindi is there. My lord, I have prayed in my first appeal, mercy petition, this writ petition, everywhere I have taken this point. And they have not decided on that. They have not gone into that aspect in any of the replies. And the second thing is, this is my first offense, which is not the case of the other delinquent. And it is specifically recorded while disposing of my first appeal petition that he had an unblemished career. This is the more important point. I would rely on proportionality of the punishment.
Where is that order?
My lord, yes. That is at page 67 of my writ petition. Point number 4. This is the entire disposal of the statutory petition. This is the difference which I would seek to point out. That confession again, which they rely on, is in Hindi. The lordship can pass orders, but I had to be fair on my part and to assist your lordship that these are the points of differences which are there with regard to Mohar Singh's case. Mohar Singh did not enjoy such points. Mohar Singh was a Hindi speaking person. He is not. And this particular point was not there. Unblemished. This is the.
Where are the records?
Record is lying with my senior, my lord, Mr. D.N. Roy, my lord. He is, my lord, not here today, my lord.
This I have doubt whether it was specifically taken. Harsh punishment I have taken. Yes, Hindi. Yes, that has been. Page 27, second ground. And this is not the first instance. I have been taking this point from the very appeal petition. Page 59, page 6. Appeal.
He has accepted. That is why summary trial has been taken.
Uh, takes the appeal petition, page 62. I should not first invite to the writ petition. I should come back to the first documents which he had submitted. Page 62. But he has been saying that there has been no admission. Page 63, point number 3. Yes, my lord, there was question put.
Not admit is fair enough, but where you did not.
There was no assertive sentence. There is no assertive sentence. There is all negation which I could find. Yes. I understand. There is no assertive sentence, though no positive. There is no positive. Well, his conduct would show that he had been contesting this from the very inception.
Was there any detection to produce the records?
No, no, you could last
Then I
order
will
it should-
just go to the expense. If anything is in your favor from the record, or else
Well, fate is almost sealed when he submitted the case of Morsing. But I tried to distinguish this on these two counts. I found out these 2 points only credible. I have to try. কবে পারবি বল? কবে আনতে পারবি?
1 week. better.
অনেক পারবি তো? হবে না। June 13.
Huh. Item number 17 to 19.
Yes, I'm for the petition. I beg to for the Siliguri Jalpaiguri Development Authority. Lord. I appear in item number 19. 19 to to. Only one difficulty. I have a personal difficulty for which I have to leave the court. Just if your lordship gives me this account, Mr. Roy is there. I already have spoken to him.
In this matter, I just argue before lordship regarding selection in the Siliguri Jalpaiguri Development Authority. And
yes,
and
yes.
they have now come, they moved it.
That we have mentioned Mr. Roy appearing on.
Yes, they say.
As far as Mr. Bhattacharya's difficulty is there, that is item number 19.
I am ready, madam. Madam.
But since Mr.
all the better the
No, Mr. Rai has already.
Then I'll refuse his adjournment, I'll clear out.
Well, at least kindly take it up at 2 p.m. Let Mr. Rai come.
Yeah, no.
I am.
Peaceful, sir. No peaceful here. Make up your mind that you're opposing this. I'll take up hearing of that. There is no difficulty. But there will be no peaceful hearing so far as any matter is concerned. You will not be granted any further adjournments. Whatever you want.
That we are ready.
Yes,
But last occasion, I argued what happened, madam. The learned advocate for the Municipal Service Commission, she was not there. So you also kindly fix a date, madam. But I.
That's not for adjournment previously also. Not that Sir Bhattacharya is asking for an adjournment.
But on the last occasion, adjournment was granted on the prayer of Mr. Rai.
Special urgency in the matter, tell me.
Urgency is, my lord, since 2011, my lord, 29 posts are vacant, my lord. in the
Yes,
city.
fill up.
But the only prayer is my humble prayer before your lordship. On the last occasion also we made, my lord, they have participated in the subsequent examination.
But that is with the leave of the court, and this is not a, that does not create any equity. That was hard, my lord. Now,
It was granted by the court. They choose to participate it.
But your
My
lordship-
lord, only thing is, if your lordship grant us liberty to publish the result.
but they have not made the, no, no. This one. Yes, this is the.
Not to participate in the examination. I'm also appearing here respondent. Here I'm responding. The rise. For the petitioner and another matter. Kindly appreciate, my lord. For next 2 weeks, your lordship will not be available. But that's the difficulty, my lord. That what I want, I can release the matter.
No, no, my lord. After 2 weeks, my lord.
Part hard. Already.
Not because the Kashmir face point that will be what on bottom link.
Respondent number 191517. Since all the writ applications
3 repetitions. I have 2 and yes.
together, then all the writ applications stand adjourned. Supplement
Yes, I also I complete it.
because I'll be having motions. This matter has to be heard of. Need at least an hour to make submissions.
I also complete it, my lord. I also complete.
The half an hour will suffice. But they have completed. Mr.
No, no, I have mentioned, I have argued, then they were not there, I have to complete.
June will be not far too far.
Get the supplementary list in on 17th June 25.
This side of the vacation, kindly.
This side vacation, I'll be taking up motions. For motion the staff, I'll be taking up motion. I can keep it, but you will come every day and go.
Kindly keep it, lordship. Kindly.
No, no, man. No, no, man. They're not. You have to fix it there.
Lordship is giving an indulgence to all of us.
I can place it mark the list of.
But then that one you can fix it there. That's one. Because we are also suffering.
Let it be in the month.
Monthly is better not hard, my lord. You also my friend. But you also can but there's a fix this matter. We are suffering more, my lord. We are the petitioner. We are jobless.
Yes.
Number 20.
Yes. Court fees deposited. Yes. Where is Mr. Ghosh? Yes, Mr. Paul. Where is Mr. Ghosh? Ascertain from the gentleman.
Code number 10. This person, the junior is there.
Who is the junior?
Code number 10. Is there. Details also in the same.
Yes.
Malad,
What is he saying?
Malad, he is saying that the junior is there, also there, I know.
No, no.
Malad, he
Arif.
is code number 10.
Then no point. It's not a question that I will hear you and keep it another day. If I hear both of you, I'll whatever, whichever way it goes, it goes.
Last question, Malad, hold that door, adjournment will be given. That's your lordship's order.
What can be done? He's not there. In his absence, how can I dispose of?
Last location also.
Very well. I'll record this and place it in June.
No, Malad, no.
Because 15 days we have in month of May. I'll place in supplementary list. So that it'll be easier for you.
For the time. Only for the timing, Malad.
This is the last matter. Aji last matter. So last matter. No, no, no. Once I go into the monthly list and tomorrow I don't take up. Since the respondents are not represented, let this matter stand. Since the respondents are not represented, let this matter. No, no, Mr. Pal, learned advocate representing the petitioners, submits that he has already deposited the deposit court fees. Mr. Pal, I'm recording. Full stop. Eta ফেরত দিয়ে দাও, এটা চাই না. I'm recording your submission. Full stop. Since the respondents are not represented, let this matter stand adjourned and appear under the same heading on. বলো জুনে in the daily supplementary list on. তাহলে তো হয়ে গেছে, দুটো তিনটে হয়ে গেছে. On 12th June. Ask, just indicate to the gentleman that they should be present on that date. It is made clear that in the event records, the production, they directed to produce records.
No, if they choose to, they will not file any affidavit opposition. They will earlier question.
The respondents are directed to produce the records of this case when the matter is taken up next. The petitioner is directed to communicate the aforesaid order. The petitioner's advocate, the petitioners are directed to communicate the aforesaid order to the learned advocate representing the respondents.
Another thing, the last occasion, directed that order was there. No further adjournment will be given to the.
No, that is all right.
And they also it is recorded that they will not file any opposition in respect of supplementary evidence. May recollect that.
I remember, not this. না করে চলে যায় কেউ বলুন আমার একটা দিন আমি কালকে আছি, সেটা তো দিয়ে দেবে।
Monthly is item number 27.
Sonojit Ghosh, he's coming, he's regular, he's coming. I am placing my case. The judgment, then he will come. No. He will come.
He's for another courtroom addressing the court. By the time he might take half an hour, 45 minutes. So if after I hear you, what will I do?
Let it be short pass over.
Not today. If I hear out both of you and I can make up my mind, I'll dispose it off. Don't use retaining the matter in the list, then I have to again fix it on another date. These are disciplinary proceeding matter.
No. This is a compassionate appointment.
His absence, I will not. It's there in the list at the top. On the next date, it will be taken out. Yeah, you can see.
No. I am not applicant.
All the list.
28.
So, it will be taken on Monday.
There in the list.
So tomorrow you will.
Tomorrow it is not taken. It's the effective Monday.
No, 28, I'm praying for the petitioner. Now, my lord, this matter relates to my lord, issuance of the service certificate and release of the Provident Fund dues of the petitioner. Yes, PF dues and service certificate. My lord, since 2010, I started working, my lord, in the month of January 2010. Then, my lord, in end of 2012, I was asked to, after joining, I was serving at Calcutta office. Then, my lord, in the year 2012, they asked me to join their Durgapur office. Now, my lord, at that point of time, my lord, my family was under crisis. My father was, my lord, a kidney patient and he was supposed to go dialysis and then, my lord, operation. That is why I requested them that right now, it is not possible for me to join the Durgapur office because I have to look after my family. And under these circumstances, you kindly allow me some more time in Calcutta so that later on I can join in Durgapur. Now, they kept on insisting me, either you join Durgapur, you have to join Durgapur. Then at that point of time, I had to tender my resignation. Now, they are not accepting my resignation because they are saying that I have not served that 3 months period, that notice period. And on that account, they have withheld the service certificate and they are also writing to the Provident Fund authorities that I am still in their payroll. That is why the Provident Fund authorities is not releasing the Provident Fund dues. But this is my very short case. Now, in the opposition that they have filed, they said that I had left the service in the month of October in the year 2010. And so my service to be counted. Again, I rejoined. My case is that the appointment letter which contains the terms and conditions of the service were not given to me when I joined. Now, after serving for more than about 6-7 months, I requested them continuously that you give me my appointment letter so that the terms and conditions can become clear to me. Then I had on this account I had to leave the service. Then they served me with the appointment letter, the conditions of their service. Then I once again started. Now in the opposition, they said that since I had joined once again, they are counting that period from that time, my lord. My lord.
Clause in the appointment letter.
Yes. My lord, this is clause 4. Clause 4 at page 25. My lord, dated 26th March 2010 at page 24. But initially it was 30th, Lordship kindly sees page 23, 31st December 2009, they are asking me to join. I joined on 19th January 2010.
Then, my lord, the conditions which were supplied to me is at page 24 onwards. Yes. Lordship kindly sees page 24. This is, my lord, dated 26th March 2010, letter of appointment for the post of junior officer, custom and transport. Now, Lordship will kindly take up page 25, the clause 4, the notice period.
Rather 36 color, I have 34 years I have. I pay for the state. 40%. There is the other person Provident Fund matter cannot wait, sir. But in my matter, he is sitting there and paid for time. And officer is also they are saying you can get 10 days. A person to enter count number 10. Action on the next day. Yes.
My lord will kindly see.
Period is there.
Notice period is there.
So when did you join?
But I joined on, my lord, 19th January 2010.
When 26 March.
24 is 26 March, but my lord, Lordship kindly takes up page 23. This is dated 31st December 2009. My lord, Lordship kindly takes up paragraph 4 of the writ petition, which I have read 19th January 2010. My lord, thereafter, this document at page 24 was not given to me. So, my lord, Lordship kindly takes up there, not in March, in October. Thereafter, my lord, yes, Lordship kindly sees the transfer order at page 28. I joined at Calcutta office. Lordship kindly sees my lord, you will be initially engaged at our head office, Kolkata, under General Manager Commercial to look after the logistic and partly marketing activities under the probationary period of 6 months. So, my lord, I joined at Calcutta office. Now, my lord, on 20, Lordship has seen my 21st February 2011, they asked me to join at Durgapur. Lordship will kindly take up the next page, my lord, at page 29, 30th December 2011. I say, Lordship kindly sees. Now, my lord, I have requested them. Then, my lordship kindly sees at the bottom, they have said, your appeal has been sent, but you are advised to comply the transfer order. Otherwise, there will be violation of arrangement order. Then, my lord kindly sees page 30. Page 30. Yes, page 30, your lordship has read. Then, my lord, page 31, I have stated under what circumstances I had resigned, my lord.
Respondents also they Mr. No. No, we were held up kindly
Yes, lordship kindly takes up page 32. This is their further communication made on 2nd January, which they say subsequently you have submitted resignation letter dated so and so, which is not acceptable due to following. At the end of first paragraph, you have mentioned I am forced to resign. The company has not forced you to resign. And in this last line of paragraph, second para is not clear. This is what they are communicating. Now, my lord, page 34. Lordship has seen that. Now, Lordship kindly takes up page 34. In continuation to your resignation letter dated so and subsequent letter dated so, we would like to inform you that your resignation may be accepted subject to compliance of clause 4 as mentioned in your appointment letter. Lordship, I write to them on 25th January 2012 at page 35. Lordship kindly sees that I am in receipt of a subject letter dated so in the afternoon time, though it was sent to me my permanent address, which says a conditional acceptance of my resignation, which is not clear to me. I had asked to serve the notice period at DCL Calcutta office, but I was insisted to report to Durgapur, which was not possible considering the health condition of my father. Moreover, it is a 2-year renewable contractual service which automatically got expired on 19 January 2012 after completion of 2 years from my date of joining. As per the terms of contract, I did not even receive any renewal extension letter of my contract by this time from the company, and hence I have no scope to serving 3 months from now. Therefore, it is kindly requested to accept my resignation and release me from 31st December 2012. I would also request you to settle my dues, including my PF dues at the earliest. But thereafter, basically nothing happened. Lordship, my present grievance is twofold. They should release me and not, my lord, clear allowing my the PF to my PF authority to clear my. Yes. Thereafter, my lord, again they write to me at page 36. Yes. You have been advised to report at Durgapur on so and so, and immediately after the receipt of the transfer order, you have submitted the resignation. So they say again clause violation of clause 4. My lord. At that point of time, yes. Now, my lord kindly takes up page 50. Yes, January. Yes, January 2010 to January 2012. For the first time, at page 29, 30th December 2011. Yes, 19th January. 19th January 2010. 2 years, but I notice period I did not have that opportunity at that point of time. First, 30th, 9th January, you were in service. Yes, I was in service. Only for that period. Only for some 9 to 10. No, at that point of time, this clause 4 that during the contractual period, your service is liable to be terminated on 3 months notice period in writing or 3 months salary in lieu of notice if your performance is found. There is no option. There is no option of that. Yes, page number 24. Page 23 is the initial letter of appointment. Lordship kindly sees page 23. This is the initial letter of appointment. The bottom of page 27. Signature. No. As a token of acceptance. No. Yes.
How can you annex this?
Sir, you are not in time.
I'm always. Sir, I am always late. Perpetual late.
Lordship kindly sees. Yes, your. page 27 does not, there is no provision for me to sign.
When something is on record, Mr. Dey, have patience. The court will take into consideration those documents.
Yes, yes, but my lord, my page 20, yes, my signature is definitely there. Then my lord,
So you accepted this.
yes, I accepted this.
So you are bound by these terms.
Yes, I'm bind. These terms are binding on me. Absolutely.
Then why are you saying this was served late? So 2 years from the date of joining, accepted. Your contention is accepted, but the other terms are also accepted.
Yes.
Prior that, you have to pay the notice fee. Okay, naturally that will be for the period which is there. Are you sure now? Have you satisfied yourself? That
But I have satisfied myself. But this was signed on 11th December 2010. This was signed. Yes, prior to the resignation.
By keeping your eyes wide open, you had signed this. Otherwise, the renewal contract would never have been stopped on very normal and national. Yes, Mr. Dey. Your contention is
My lord, I am filing my affidavit in reply.
how is the contract with the parties? As per this contract, there is a limited period which was left. Have you charged him for the limited period only? Page 48, 48,478. This is for the entire period or for I read page 43 to compare. But I have seen the paper, page 43. You see, it is 3 months notice fees, 55,932. Less 12 days only. It comes to 12 days only, may be reduced to 1 more day. It may be 11 days because of the resignation details. Because the entire period is not working. So calculate this. And subject to that adjustment, everything will be over. You cannot ask for notice pay beyond the period. No. It is there. Now I find it is there from this page. There is no dispute that he has to pay the notice fee. He cannot ignore, he cannot say that I will not pay that. He has kept his eyes wide open before signing. He has signed this only because he wanted a renewal. But as it goes, you see, situation changed. It was not renewed. Otherwise, you would not have renewed the contract. That is why he has signed it. Apparently, very normal. Respondents will, authority will never permit you to continue beyond the period unless you sign the original. So that is the reason we have signed. It may not be very clear from whatever it is. But this is a contract.
My lord. Yes, sir, this is binding on me.
30th first and 9th January you have to pay. And your currently may get reduced. I do not know. That is not there.
Let them bring the calculation then.
Yes. And I'll dispose it of
Yes.
That's small matter.
Very small matter, very small matter.
He has to pay that.
Because he didn't have the 3 months time to serve.
No, I did not have that. So that your lordship is aware. No, lordship, kindly let them bring one calculation.
Give one respect to the
No, so far as this part is concerned, sir, no further arguments.
No, I won't. Let them bring the calculation, give a copy.
Otherwise, the further arguments will again be advanced. Yes.
Difficulty with the company, it is not on the payment part.
The thing is Durgapur Chemical Limited. That has been, that is the government notification, Lordship, kindly. And it is, we are thriving on the government funding, nothing. So it should be completed here and the application here. Not necessarily. I don't have any generation, I don't have any fund. That is the whole level. But I that we see. When any observation will be fallen from your lordship, that is binding. But no, it is not different. I'm not standing in a way for non-payment. But this is my dedication.
আরে
This is
তারাও
my
মামলা চলছে, তবে ফোন করছো কেন তুমি?
This is my dedication. And kindly, in any direction, then government is required. Otherwise, I cannot pay anything. I don't have any fund. Government pays me the salary, give me the. Once the order is passed, what I request kind approval. Give a notice to the government. Let them come also, because government is unless they are submission. I'll record the submission. I will record your submission. If there are funds to pay, I'll record your submission. I don't have any fund. I'll record your submission. We presently have issue and we find chemicals limited to disperse Provident Fund along with the rate of 9%. And so far as Provident Fund is concerned, it is the trust is not with us. We have surrendered the entire trust to the RPF. So if anything is required to be paid, my reference client is required to apply in proper format, nothing. The money is not with us. Provident Fund is also not with us. We have transferred the entire amount to Regional Provident Fund Commission.
The Regional Provident Fund Commissioner is the party here. May I?
Yes, yes. I'm not standing in a. I'm nothing to say. Yes.
Well, I can give them a notice and come back so that they can appear before Lordship, and so that direction may be passed upon them, because the amount is lying with them.
Their party.
Yes, their party.
Yes, their party. Have you served on them?
Yes, yes. I'll just could I just check up? No, this is 2013 matter. I'll check up for your Lordship.
Contracting. Conditions. Government condition. By cover of letter in 26th of by letter dated 26th of
March.
The petitioner contains that the same was served. The petitioner sometimes similar to the signature of the petitioner also appears on the signature of the petitioner as also the charge of the respondent number 1 and
My lord.
copy of such document as made over.
Well, this is also in their affidavit in opposition. Yes, my lord. Page 17 of their opposition.
as we normally go today by the learned advocate, because it is also not reflected in any of the order that you are relied on. As made over in court by the learned advocate, correspondence is taken on them. This forms your basis. Yes, it will not be here. It would have been in difficulty.
ওটা হয়তো আগে হিয়ারিং এ দিয়েছিল না কিছু না।
Should I claim that he was? Where is the transfer order? Should I claim that by an order dated 21st of February?
হ্যাঁ page 28 yes but page 28 your lordship is at 21st of
Transfer order is in accordance with the clause such and such of your letter. Page 28.
but 21st February 2011
Yes.
Transfer order is of 21st February 2011. 11, I understand.
this probably will have to be 21st or 12th. This has to be 21st 12th. It has gone down as 02, but this will be 12 because they are asking me to join by 2nd January 2012.
You'll also kindly take the trouble to consider page 29, where when undersigned client is writing,
Yes.
I am in receipt of your transfer order dated 27
On 27 December.
So it may be.
So you accept that. You accept it.
Whatever lordship. Yes, it is right. No, it is right. It comes from the second page itself.
Claim that by a transfer order dated 21st of December 2011, wrongly transcribed as 21st February 2011, was transferred. From Kolkata, Durgapur works for the respondent number 1 and was advised to get release order from the head of the department. Insurance is that by reasons of personal inconvenience, had made a representation addressed to the compensation, respondent number 1, and had requested considered this transfer. Not revealed that his representation was in turn followed. Because revealed that though his representation was forwarded, that would do that. Records reveal that though his representation was forwarded, competent authority had advised the petitioner to comply with the order of transfer. Such fact would be from the motive appearing on the petitioner's appearing on the petitioner's representation dated 30th December 2011. Forming 2011 at page 29 of the data. In response to the petitioner's notification, responding of same Yes, and the petitioner having to accept the petitioner's request. With us. Since sheer contract and such period having expired. The petitioner and such circumstances. We also seek guides on what made by responsibility. That can be academic. It's a day learned that cannot be academic. It's not it's a service. Finally setting plus this except should also be because this person so for conflict is a deal of so it's that Shiller submits that Shiller was the picture was aware that the picture of John that he was appointed part of the respondents are never forced. The tender is execution. So, the petitioner has tendered his execution. Yes, yes. That line should be there. He did not argue anything. And later, in the later it says.
But I just place that later. না, ঠিক আছে।
আপনি লিখেছেন সেটা
হ্যাঁ, হ্যাঁ।
আপনি deny
The respondent number one had never forced the petitioner to tender his resignation. Had never forced the petitioner to tender his resignation. The resignation tendered by the petitioner was on the basis of his own position. Once the petitioner tendered his resignation, because he is bound to adhere to the terms of appointment so far as the same relates to notice fee. Mr. They, however, candidly submits that the original contract period of 2 years was not reduced. Was not. Was not. Insofar as Provident Fund is concerned, where is that document? Insofar as Provident Fund is concerned, go. Previously, Provident, previously, the respondent opinion exempted. Because exempted, no respondent exempted under section 70 of the Employees Fund. And this funds and miscellaneous provisions act. Such exemption was later not. Such exemption was later surrendered, and the entire trust fund has been transferred to the
Employees Provident Fund or
Employees Provident Fund Commissioner, where
organization.
organized where every document.
No, I have no. Recently it has happened. That's all. On instruction I have to on Lordship, will your Lordship kindly take note of this? Government has.
You have to pay. You cannot say that I will not pay.
I am not.
Say finally settlement of you. That is why that is never execution.
Yes.
I will come to. It is seen from the subject that at present the respondent of the terminal beneficiary appropriate direction to reaching on the state. You cannot say that.
I think reverse. That's the thing. I cannot say Lordship state because the state
No,
is. But the difficulty is unless this is on record, it is brought on record because due to pollution, West Bengal Pollution Board's direction government has closed it and only paying the money, paying the salary.
That you have to.
Not I have. Government has closed.
That's it.
Government has closed. I didn't do anything.
By placing reliance on by the government of West Bengal at present all box and respondent of Number one, in terms of the but the petitioner had also accepted and confirmed signature of the petitioner appears. As an acknowledgement, same as an acknowledgement, he had put his signature at the bottom of the same. Because revealed that though the petitioner was issued a transfer order, transfer was instead had tendered his resignation. Whatever we tendered his resignation. Record also repeat. I find that the very I however find that it very submitted by Mr. It has been very submitted by Mr. A. Learned advocate that's not that original contractual period of 2 years what was not extended.
No, it is
Was not extended. Having regard to the process, I am of the view that the petitioner would not have been called upon to payment of rupees or the period beyond contract. As such, the petitioner at best was liable to be for the period between
The date of resignation and the 2 years contract,
30th of
December.
December 2012 and 19th of January 2013. Is that correct? Or 2011? Yes, 2013.
2012. 2012.
Few thereof, I directly respond. Compute the demand on account of rupees pay. Sir, this letter says that Provident Fund
My lord is at page 55, Lordship kindly considers page 55. This is from the Employees Provident Fund organization, which my lord, according to my line senior friend, my lord, the amount is lying with this particular organization. This was written to me, written to the Assistant Commissioner, Provident Fund Commissioner. Lordship kindly goes through this letter, my lord. But this was I was trying to show, page 55. This is very vital document, my lord.
This is letter of 2013.
2013, yes, 15 March 2013.
And the transfer of the entire fund.
Transfer is later.
Later, that's right.
Let such fresh demand be laid from petitioner within 4 weeks from the date of the petitioner shall be required to make payment.
May I make my submission? Yes, I cannot make payment to them. The amount is lying with the Provident Fund authorities. Yes, yes, yes. They will write to the Provident Fund authorities giving the fresh calculation.
Fund is different. Lordship is talking about the notice pay
Oh,
as EL.
But the
After deduction.
Interest.
principal amount.
Notice fee. Final settlement, I think only EL is there. Earned is there, otherwise nothing, because the calculation which I have been provided with.
Such demand is made. Within the respondent shall take appropriate steps for forwarding all particulars of the petition to the Provident Fund of small the Provident Fund of disperse the petition.
So my lord, they will raise a claim to me. I will make payment to them, and then they will write to the Provident Fund authorities. I'll just make payment to the notice pay to them, and the for this 9 days. For this 9 days, then they will, my lord,
Payable because 9 days on leave is there.
yes.
No, something will be payable still there.
But that is why I was just beseeching your lordship, my lord. This order has been recorded. I need not come and argue anything on. They will just, well, they'll just come with the calculation so that everything can be settled by your lordship. Because I need not argue anything. Lordship has recorded everything, my lord. I cannot reopen.
টোটালটাই তো রেগুলারাইজ করে দিলেন আপনার রিলিভিং
সেই জন্যই বলছি।
রেগুলারাইজ করে দিলেন আবার nothing to
And my lord, regarding that service certificate, my lord.
And needless to know, the respondent show much. We have to either payment of the sum. The respondent shall
after
Yes, only for that period.
after completion of the other formality, I do not know whether no, that is there. No due certificate or anything are required to be signed or not. That is the thing. After completion of the formality, nothing else. I am not standing in it.
But I'm grateful to your lordship.
After completion of other formalities, if any, only one line.
Other format. Service certificate you issue to him. Raise the demand. Yes.
Well, would it be your lordship's last indication that the Provident Fund authorities
The petitioner shall be at liberty. The petitioner shall be at liberty to apply.
and my lord, they should also, my lord, release the amount. Otherwise, again, if the Provident Fund authorities, my lord, withhold, then again I have to come back for.
You have to come back a second.
But this is such a small amount of money for that. Every time, my lord, I have to. But if every time I have to come back, lordship, some deduction on the Provident Fund authorities. Otherwise, my lord, this is such a small amount, my lord. It will be difficult for my client to come again and again. Get. Yes, that. Only that. No, of course, I am not saying anything which I am not entitled to. The amount that I am entitled to. Grateful to your lordship.
29. This is my application. And on the last occasion, your lordship directed me to survey notice upon all the respondents because on the last occasion they did not appear. So I'm filing.
We don't have any copy of affirmed affidavit in opposition because I get new assignment. New appointment.
Agreement of service. No.
I get new appointment with Mr. Pinaki.
You don't have a copy.
I may supply. Also, I visited.
It's not filed in court. Yes, madam. Have you checked up the records?
Last order.
The last occasion, since you did not appear, I directed service on you. Or notice on you.
Order lordship. They are recorded that yes, opposition appears on the record. Therefore,
yes. Not filed in the department also.
But
anyway, not necessary for strain yourself very further by preparing a video. The court can
well, a copy of the affidavit of opposition has been served on me and
have a copy. It is not necessary. Let them produce the records.
lordship.
In terms of the order dated 6th of March 2024, the petitioner claims to have served a notice of petitioner claims to have communicated the said order. Mr. Bhatt, learned advocate.
I'm led by Mr. Bhakat. I'm Mr. Kundu.
Submits that the petitioner had been communicated 6 March 2024. Respondents and all their advocates. So, the service showing demonstrates communication of the order by the petitioner is taken on him to submit popular appears on behalf of the state respondents. She submits that although an affidavit of opposition had been prepared by the state respondents, it remains untraceable and or has not been filed. She pays for leave. Filed a fresh affidavit of opposition. She pays for leave to Liapa. A copy whereof has already been served.
I will. It is affirmed on. 25th day of July 2014.
Having regard to the aforesaid, leave is granted to the state respondents. Herefore, which had earlier been 6th of July.
Yes. Well, they will produce the records on that day. They will produce the Lordship. Well, this matter will appear in the monthly list of June. Well, I will used on reply to the opposition also.
Reply you have already filed.
Lordship.
Madam, same copy. No, what should be changed? Get a copy from him. Just reaffirm it.
Lordship, I beg to appear on behalf of the Public Service Commission. On the last occasion, Lordship has granted leave to reaffirm the affidavit in opposition. May I file the affidavit in opposition?
Lost.
Lordship.
But they have filed that.
They have filed a reply.
Reply is already there. Well, I am filing a supplementary affidavit because a document which was not included in either in the affidavit in opposition nor in the. This is important for just you, Lordship. Will
The pleadings are completed and at this stage, 2011.
Why did you not?
just because experience dispute is regarding experience only, nothing else. They said that I have no experience, required experience, but I say that I have not 3 years but 8 years experience. I have the document. This is the only issue. Look, because your Lordship will, yes, reply is already given.
Why did you not
Because Lordship will kindly consider this is a transfer brief.
This is the affidavit in opposition, Lordship.
Yes, it is affirmed. It is affirmed only because of certain documents which will show that the experience required. It was misplaced at that moment.
What was misplaced?
If you Lordship, please just go through it. There is nothing more, only a document which will show that the required experience was there.
About 2013 matter, what is the case?
Lord, the petitioner applied for a in the selection test for a surveyor, for the post of surveyor. And he was successful in the written test. He was placed in the 4th position in the panel, merit list. In the first interview later, he was given the interview, but because of something, the interview was postponed. Subsequently, he was not issued any interview letter. He went to the office to inquire what happened. They said that you have no required experience of 3 years. But I show that I have 8 years experience. I have the documents.
Lordship, in the advertisement for surveyor under Public Health Engineering Department, it was clearly written that the qualification required is first Madhyamik examination of West Bengal Board of Secondary Education or its equivalent examination, National Trade Certificate from Industrial Training Institute in the trade of surveyor or senior surveyor certificate from West Bengal Survey Institute. The advertisement, Lordship.
This is not.
Lordship, I have just. Lordship, I can only reaffirm, Lordship.
The same thing happened for me also. I could not also, because this was a transfer fee. Now, I know, my lord, I know. I am just seeking your lordship.
Advertisement number 16 of 2011.
Yes, Lordship. Lordship, number 1, surveyor under Public Health Engineering Department. Qualification, Madhyamik examination of West Bengal Board of Secondary Education or its equivalent examination. Second, National Trade Certificate from Industrial Training Institute in the Trade Survey or Senior Surveyorship Certificate from West Bengal Survey Institute. Bandel or its equivalent. 3 years practical experience in survey works. Lordship, the petitioner has obtained National Trade Certificate in July 2011, Lordship, which is at page 33 of the petition, Lordship. Whereas he has annexed the experience certificate, one from a consultant firm issued on 2nd December 2005. The period is 1st April 2003 to 2005, and another from ISKCON Bondal, that is with period from 2005 to May 2006, where Lordship he worked as survey helper. But the thing is, Lordship, he has to first obtain National Trade Certificate, then obtain the experience. He has not obtained experience after he has passed the national.
That he had to first obtain experience and then certificate.
Lordship, because he has obtained trade certificate later on, Lordship.
Practical experience in survey work.
But first he has to obtain the certificate, then he has to obtain the experience certificate.
Nowhere it is written. Nowhere it is stated that I have to first obtain. Look, in
Why did he call it for interview?
Lordship, he was called for interview earlier, but that interview could not be taken up due to some unavoidable circumstances, and later it was found that he is not eligible.
I want to know how many persons have you appointed and all disclose all records in connection with the trade certificates issued to them and their experience.
Lordship,
how many persons have you appointed in terms of this advertisement?
this 2011 advertisement I have to, because it depart.
Who is appearing in you? Ask him to find out. There are temporary posts likely to be permanent.
Lordship, this was the defense taken in the affidavit in opposition, Lordship.
Where is the defense? $26 posts.
Yes, Lordship.
How many posts have been filled? Say that he has not acquired the
Experience before.
Submit awards as per advertisement condition. Where is that advertisement?
Lordship, according to the commission, he has to first obtain the national trade.
Now you see, come to technical assistance. With the Office of the Cultural Research Institute under Backward Classes Welfare Department. This is one. What is the qualification? Essential qualifications. Bachelor degree. That you find there.
Yes, Lord.
He is a commerce graduate.
What is the after the essential qualification?
But here it is.
Information. Let us understand from here. Up to 6. Can we place 6?
Yes, Lordship, where experience of a number of years is prescribed as an item of qualification, this would mean only research experience gained in full-time employment research for the periods up to the closing date. Certificates from the head of the organization for entire experience claimed clearly mentioned the duration of the employment, indicating basic pay and consolidated pay must be furnished together with application. The certificate should be mentioned the nature of duties performed, experience obtained in the post.
It does not say that the experience should be post the acquisition of essential qualification.
Generally, when we obtain any experience in any particular thing, we first obtain the certificate of that.
And that to obtain that certificate also, I need 3 years experience. That is 3 years.
What is the qualification?
Graduate.
Get a trade certificate.
Yes, he has got.
Get a trade certificate.
Okay. Yes.
No.
That is why I wanted to show the affidavit, supplementary affidavit in the. Yes.
A copy of that.
Yes.
You must be having a copy of
Yes,
that.
I
Copy. The other copy.
Other
Your copy.
Yes, mother.
You did the original.
It is similar to on the. I'll share. So just to one. Serial number 3. This is also. All right. I'll show.
His written lordship, the experience acquired after the minimum prescribed qualification will only be considered.
Candidate must have the minimum prescribed qualification awarded.
After the minimum.
X.
3, lordship. Point number 3.
Point number 3.
Second line, lordship. The experience acquired after the minimum. Point number 3, lordship. of instructions guidelines for applicant.
All degrees, certificates, diplomas. BTRS must be obtained from recognized institute.
Which Lordship is reading this page. He has
Yes, I have
his
already
document.
thought.
Lordship, at page 30 of the,
Yes,
that is what
page
he's reading,
30.
Lordship.
Page 30.
Lordship, kindly see point number 3, Lordship. Candidate must have minimum prescribed qualification awarded by the recognized examination board required essential for trade applied. Second line, Lordship, the experience acquired after the minimum prescribed qualification.
Not qualification. To acquire the trade certificate, there is some minimum qualification. That qualification.
This is item number, serial number 1, Your Lordship. Serial number 1.
Yes. So to
Can we-
acquire this, he requires
3 years experience.
and that is there in your notification. I think supplementary.
Should I try? I have sub copy.
The field of the post.
It's a long time back, Lordship. So interim order, the matter was dismissed for default also for long time.
What will you do now? Find out whether there is any post or not, or the next available vacancy. It's very clear, madam. You ought to have considered this.
You should kindly grant me 1 day time, Lordship. I may take instruction on this point, Lordship.
Answer to the 2023 petition number.
This is petition number. Which one will
WP number at the top.
WPA 23 33043.
Written wrong, Lordship. This should be 2013, 2013.
Oh, sorry, sir. This is number wrong.
You cannot correct because. Get this.
Yes, yes, yes. With leave of Your Lordship, may I correct it?
You cannot correct it.
This clerical mistake. With leave of this.
Yes, madam.
Lordship, kindly grant me 1 day time. I shall.
I can understand the situation. See, read this. This is public notice calling applications for appearing in All India trade test. And I will follow this.
Yes, Lordship.
So this is the minimum requirement for appearing at trade test. Now come to your minimum qualification. Now read. Sir, madam, you did not understand this. Means you, your officers did not understand this. For rejecting his candidature.
Then why they have issued notice for interview?
How many persons have been appointed? 26 persons have been appointed. I want to find out what happened in their case.
Let them produce the record.
What is going on, madam? The technical examinations, madam. This is no ordinary examination. Technical examination, trade test.
And he is posted as, his position was 4th.
Yes, you are permitted. Get the certificate.
In spite of having the top position in the merit list, he
Grant me
was
some
not
time. I
given.
cannot do.
Something fishy is there.
Disposito, best.
I think your lordship may, my lord, lordship may kindly ask them to produce the record. As your lordship, please, I will not say.
Become academic? Want any inquiry to be conducted? What do you want? You have been wrong.
Yes. How many posts are there and how many posts have been already filled up? That's all. Yes.
Should grant me one day time. 11 years have passed.
Client has nothing. There be instruction on facts. Instruction on knowledge. Get this. See, for qualifying for a trade test, this is the minimum qualification required. Experience is required. 3 years experience. Candidates who are working continuously with the till date for minimum 3 years in industry, institute, organization in relevant field based in Delhi are eligible to apply. You are in Delhi?
No.
Then
And this is the notification
Organizations
of
relevant
government
field
of
based
XLT of
in
Delhi,
Delhi.
Lordship.
Based in Delhi means he
is
can
for West
also
Bengal.
apply in Calcutta.
it should be the same.
Lordship, I need to find out, Lordship. I cannot.
You must be having a you disclose
Grant me one for the trade.
for trade test, whether any experience
3 years.
required or not.
Lordship, I shall try to obtain from the department, Lordship.
One thing is very clear from this, whether this applies to West Bengal or not. In respect of trade test certificate,
Yes.
Whether 3 years experience was.
industry has to be counted. It's a trade certificate. It's not an LLB degree. They're only after
Lordship, I am the last person to stand in the way. Lordship, I have just appointed. Kindly grant me some time. I shall.
answer only. It's a legal answer. Client cannot advise you on this.
No, Lordship, I'll try to find out the West Bengal.
Also what difference to make. It's an experience. And you rejected his candidature. Proceeded on the basis of instruction you are submitting. Poor client rejected his candidature based on his experience, being experienced prior to his acquiring a trade certificate. If he was working in some industry prior to this period, somewhere, and he has disclosed the trade certificate, how does it, can that be discounted? Madam, what you are trying to say, you were looking at it as if without the trade certificate, he could not have worked. But looking at this, he means for Delhi. He is certainly entitled to what is a trade certificate. This is not a qualification, separate qualification as such. He has acquired that on the basis of his past experience. Supplementary, please take it on record. Mr. Ray Learned Advocate.
Ajoy Ray.
You are Ajoy Ray.
Ajoy.
Learned Advocate representing the petitioner by placing reliance on the public notice as regards all India trade test submits that one of the minimum qualifications for appearing for acquiring trade test is to have experience in any industry, institute or organization. The petitioner had acquired, no, the petitioner not only had the essential qualification for being appointed as a surveyor, but also had practical experience in survey work. Notwithstanding the above, the respondents in the most arbitrary manner, are considered to disqualify the petitioner's candidature after the petitioner's interview. Public Service Commission. One of the affidavit of the Public Service Commission.
Monthly list of May.
Lordship. Yes, Lordship, I'll just ask for them. Give me 7-10 days time. I'll be. Yes, Lordship. Lordship, you can keep any day in May, Lordship. Lordship.
16th May. I'm obliged.
I'm grateful, my lord.
Grateful.
Lordship.
So also come up.
I'll.
Advertisement has been invited on.
As the.
In that case, I have to pass the interim.
As the state is not a party, I have to take instruction from the Public Health Engineering Department. State is not a party here, I find. Because Public Service Commission only recommends. After that, the post will be filled up by the department, Lordship.
The respondents are also needed to assert whether they
Of surveyor.
whether there is a surveyor vacant under the Public Health Engineering Department.
Department of Public Health Engineering and the Department of Municipal Affairs.
The Department of Municipal Affairs.
Or any other department. Because
Respect whereof the advertisement number 16 of 20 of published by the Public Service Commission. Where do I get that this is also in respect of the municipal affairs? Oh,
Lordship, I got he has annexed one, yes. From there I found, Lordship. Otherwise, in the advertisement, it is only written, Lordship, Public Health Engineering Department.
this public health engineering senior.
Yes, second part, Lordship, but he has annexed in the petition the list, Lordship, where initially his name was appearing. Page 35, Lordship. Page 35 of the petition, Lordship. Lordship, got the list? 35. It's in my Petition is marked as 35 P7.
35 P7. Yes.
Lordship, here it is written schedule of interview for recruitment to the post of surveyor under the Department of Public Health Engineering and the Department of Municipal Affairs. From he আপনি কোনটাতে apply করেছিলেন? Yes, yes, yes.
It was
কোথায় আছে সেটা?
he applied for both and he passed in both the
Municipal affairs. Which will come out under the advertisement number 16. Past. In bracket 1 and 2. Oblique 2011. Issued by the Public Service.
I shall also ascertain from their records, Lordship, in which he applied.
Again.
Yes, Lordship, I got it.
this at first he was allowed to appear in the interview, but it was postponed.
First question, why he was
There is no explanation why it was postponed.
Yes, Lordship. Lordship, let me find out from this is for
Now-
Delhi, there must be some for West Bengal, Lordship, just
No, no.
sometime I'll,
Surveyors are there. Ordinarily, surveyors work.
because it's
on the field.
specifically written New Delhi, that's why.
Maybe.
And this is when it is examination is being conducted by the
In other
Public
survey
Service
works also,
Commission,
in
West
other
Bengal
survey works
Lordship,
also.
West Bengal Lordship, that is why I'm
It is
just
a question
thinking.
of a grant of trade certificate. So unless a person is issued a trade certificate,
Lordship,
he
here
cannot acquire any experience. That is not so. The advertisement also does not identify that.
but
That acquisition of experience is post acquisition of the
Lordship, I
trade certificate.
followed your Lordship, but at the same time he has relied on the Delhi notification.
Yes, that
And
is the
this is-
reason why you are getting
This,
time.
this is not Public Service Commission.
Very well. Call the original side matters.
Original side item number 1.
Mr. Rai is there. Yes. আজকেই আছে Yes.
Lord, my lord was hearing this matter, Lord. I was moving it on the last occasion when my learned friend, Lord, my lord was pleased to direct that he didn't seem to be very comfortable with the situation he was faced with, and he said he'll take instructions, Lord. So, Lord.
Yes, my lord. I have taken instructions, my lord. My lord, there are two things. My lord, if your lordship sees, my lord,
No, you just place the case.
Lordship. Lord, so, Lord, I was explaining, Lord, that there's a system of Lord, passing a draft assessment order, and then Lord, sending a draft of the proposed order, and Lord, then there is time available, Lord, to file objection, or Lord, to
draft assessment order for the purpose of
for the purpose, Lord, this was that international transaction situation, Lord, where Lord, I had transactions with Lord, overseas entities which were associated with me. So Lord, they needed to make sure the law requires them to see to it that the transactions between me and my associated enterprises were at arm's length. The pricing was at arm's length, and that India did not lose any tax by the process because it was undervalued or something like that. So not for that, the procedure is that once I file my return, the assessing officer is empowered to refer the matter to the transfer pricing officer, and he is the expert, so to say, regarding the valuation. He determines whether the transaction value is the arm's length price, which would have been paid by two unconnected people, or whether it's influenced by the relationship. So he then makes an evaluation. He sends it to the assessing officer. Now the assessing officer then prepares a draft of the proposed order based on what he receives from the transfer pricing officer, and then he sends it to the assessee. So the assessee may, at that stage, the assessee has the option.
Object, accept, or proceed further.
So in this case, along with the draft, and I shall show the document, it clearly is described as a draft order. Along with the draft order, he sent me a demand notice and a notice.
I remember. So you could not have issued the demand notice without waiting for the response, for your response.
Even if at best, that demand notice was a draft demand notice. It cannot have any more legal effect than that. It's a proposed order, a proposed.
So you respond to that?
I did. Now I did. So what I did was I filed objections before the dispute resolution panel. That is what the law says. I informed the assessing officer. The dispute resolution panel dealt with these objections that I had filed. They felt that the adjustment was on the higher side. They reduced the adjustments. Now, after that, the transfer pricing officer, in terms of the directions of the DRP, worked out the figure. And then the matter was to be dealt with by the assessing officer. He was to complete the assessment. And because there was a reduction also, so the assessing officer was required to pass the order of assessment, which would have then been appealable. Now, he did not, for whatever reason, the department will know they made a mistake or whatever. He did not complete the assessment. He left it at that. Now,
he did not complete the assessment.
No, he did not. Now, he was informed that I filed the objections in the penalty proceedings. I had informed.
So it remained as a draft.
As a draft. Now, that demand notice, which was sent with the draft, which is not for the original proposed, the addition, but that was sought to be enforced. So then, without completing the assessment, I was asked whether
that you are challenging here.
Lordship. Now, there were some proceedings in the department in the sense that they wanted me to put in. They wanted to know if I preferred an appeal. And if I had, then they wanted me to put in 20% of the amount. So I informed them that the assessment itself has not been completed. So how can I prefer an appeal? And the amount there's no question of payment of anything on the basis of a draft. So twice this exchange happened. Then they sent me there's a section 245 under which if I have a demand for 1 year, I'm not a refund due to me for another year, then they can set it off. They can adjust it. So they sent me such a letter saying that proposing to adjust. So I informed them that this is the state where matters rest as far as this assessment year 17-18 is concerned. So therefore, there is no question of adjustment. There is no demand in the eye of law. You have issued a notice of demand with a draft order, which has never been finalized. So I responded. Then they sent me another one. In December 2023, they sent me another such notice under section 245. So then since they were not resolving it, then that's how the matter has come before my lords, because
you did not accept it.
I did not.
At no stage.
At no stage.
Very well.
At no stage, because it was a draft. If they had sent me, and the issues, I may point out, this is my pleading also, that the issue.
Then let them complete this.
But the time has gone by. But the time.
So there is a limitation.
Yes, ma'am. And but I may point out that the issues on which the adjustment was proposed, not all, they are repetition of adjustments made earlier.
What is the limitation?
But it is 1 month from the end of the month in which the directions are issued by the dispute resolution panel.
If it is not done, what will happen?
But then there's no
The order passed by the dispute resolution panel will become final.
But that order, it is, that order by itself is an interim stage of the proceedings. There is, that order by itself is not appealable.
What is the effect of that if it is not finalized?
Those are directions which have not been carried out by the assessing officer. So he was obliged, I'll paste the section.
It cannot be that it will lapse, everything will lapse.
No, that's what they've allowed to happen.
Let us understand from the section itself. একবার অর্ডারটা দাও আগের দিনের যেটা ছিল একবার দেখে নিই। Yes.
But if my lord is pleased to have section 144C.
Yes.
Subsection 1.
Yes.
Yes, may I place it? The assessing officer shall, notwithstanding anything to the contrary contained in this act, in the first instance, forward a draft of the proposed order of assessment, hereinafter referred to as the draft order, to the eligible assessee, if he proposes to make on or after the 1st day of October 2009, any variation which is prejudicial to the interests of such assessee. 2.
So variation means there is already an assessment.
No, I have filed a return. He wants to make a variation to my returned income, which is to
So
my
that is the variation.
That's 2. On receipt of the draft order, the eligible assessee shall, within 30 days of receipt by him of the draft order, file his acceptance of the variations to the assessing officer or file his objections, if any, to such variation with the dispute resolution panel and the assessing officer. 3. The assessing officer shall complete the assessment on the basis of the draft order if the assessee intimates to the assessing officer the acceptance of the variation, or B, no objections are received within the period specified in subsection 2. So not in either case he has to complete it. Now I'll explain what happens where I file objections. The assessing 4. The assessing officer shall, notwithstanding anything contained in section 153 or section 153B. But 153 is the period for limitation for completing the assessment. Or 153B, pass the assessment order under subsection 3 within 1 month from the end of the month in which the acceptance is received, or the period of filing of objections under subsection 2 expires. 5. The dispute resolution panel shall, in a case where any objection is received under subsection 2.
This is not the case.
But this is the case, no. My case is where I file objections.
You have filed objection.
I have filed.
So 5 does not come in where any objection is. Yes, yes.
It comes in.
Fair enough. Yes.
The dispute resolution panel shall, in a case where any objection is received under subsection 2, issue such directions as it thinks fit for the guidance of the assessing officer to enable him to complete the assessment. So this is the directions which are issued to which will enable him to complete the assessment. 6. The dispute resolution panel shall issue the directions referred to in subsection 5 after considering the following, namely, draft order, objections filed by the assessee, evidence furnished by the assessee, report, if any, of the assessing officer, valuation officer or transfer pricing officer or any other authority, records relating to the draft order, evidence collected by or caused to be collected by it, and result of any inquiry made by or caused to be made by it. 7. The dispute resolution panel may, before issuing any directions referred to in subsection 5, make such further inquiry as it thinks fit, or cause any further inquiry to be made by any income tax authority and report the result of the same to it. 8. The dispute resolution panel may confirm, reduce, or enhance the variations proposed in the draft order, so, however, that it shall not set aside any proposed variation or issue any direction under subsection 5 for further inquiry and passing of the assessment order. Explanation. For the removal of doubts, it is hereby declared that the power of the dispute resolution panel to enhance the variation shall include and shall be deemed always to have included the power to consider any matter arising out of the assessment proceedings relating to the draft order, notwithstanding that such matter was raised or not by the eligible assessee. 9. If the members of the dispute resolution panel differ in opinion on any point, the point shall be decided according to the opinion of the majority of the members. 10. Every direction issued by the dispute resolution panel shall be binding on the assessing officer. 11. No direction under subsection 5 shall be issued unless an opportunity of being heard is given to the assessee and the assessing officer on such directions which are prejudicial to the interest of the assessee or the interest of the revenue respectively. 12. No direction under subsection 5 shall be issued after 9 months from the end of the month in which the draft order is forwarded to the eligible assessee. 13. This is the one regarding limitation. Upon receipt of the directions issued under subsection 5, the assessing officer shall, in conformity with the directions, complete, notwithstanding anything to the contrary contained in section 153 or section 153B, the assessment without providing any further opportunity of being heard to the assessee within 1 month from the end of the month in which such direction is received. Now then the
issued on the subsection assessee shall, in conformity. Any consequences spelled for, like section 73 of the Civil Procedure Code, not section 73, order 21, rule 73, 74, 75. If any consequence is spelled for here, if what will happen to understand whether this is mandatory or not.
When the time limit is specified, because section 153 lays down the period of limitation. Normal course, what is to be done by what date, as far as the assessment proceedings are concerned. Now, this is an overriding provision, which say that notwithstanding that this is the time limit, otherwise the consequences that my return stands accepted. That is the consequence.
I see. So this provision is an exception to 153.
Yes, because repeatedly.
Where it starts with the line, word, notwithstanding, just show me.
First, subsection 1 at the opening subsection 1.
Notwithstanding anything contrary in this act. So ordinarily, it is under 153. Just show me 153.
Can you also see 13 once and subsection 13, then go to
Yes.
Upon receipt of the directions issued under subsection 5, the assessing officer shall, in conformity with the directions, complete, notwithstanding anything to the contrary contained in section 153 or section 153B, the assessment without providing any further opportunity of being heard to the assessee within 1 month from the end of the month in which the direction is received. So it overrides the normal limitation to say this.
That is why he's feeling difficulty now, because everything goes.
But there's one more aspect, and there's an assertion in my petition that the matters on which they wanted to make addition, the same issues were raised in the earlier years. On those issues, I have succeeded up to the stage of our court. The matter traveled up to the tribunal. I succeeded there.
Then I have to hear on the basis of affidavits. If he agrees to this, I do not know how he can agree. He'll find it difficult to agree to set it aside. Once this is set aside, nothing remains.
That is why
you cannot fall back now. It is gone.
But that is on the first day, my lord, I said.
So this has to be decided.
The lordship will state, my lord, and
yes,
have to use an affidavit.
It has to be decided.
That if the enforcement of the demand notice, my lord, should be stayed. Because my lord, time and again, my lord, they're writing to me, my lord, I am writing back to them, but they're not.
My lord, this demand notice, my lord, in respect of, my lord, assessment year, my lord, 17-18, but that has to be stayed. My lord, because,
And also, my lord, the penalty notice.
yes, but 17-18, my lord, lordship will kindly mention the assessment year, because.
Yes, show me the pages in order to the show me the pages. Which page?
But the, my lord, will find, my lord, the demand notice, my lord, at page 362, my lord. But kindly look at page 3, if I may just show my page 363, my lord, kindly have volume 3. I'll just show my lord how it came, my lord. Kindly first have a look, my lord, page 363. But kindly see.
This is the original assessment order.
The draft.
This is a draft assessment order. Under section 144
C1. Now it says, Lord, kindly see draft assessment order.
Yeah.
Then, Lord, Messrs. Almatis, etc., file return of income, admitting an income of nil. Case was selected for scrutiny and notice under 143 dated so and so was served. TPO wide order under section 92 CA3 in so and so has communicated the total quantum of arm's length adjustment is computed at 41 crores. In this instant case for assessment to 1718, in view of the provisions of section 144C, this draft order is forwarded to the assessee as the proposed assessment order for assessment year 1718. Assessee is required to file its objections or file objections to the dispute resolution panel, acceptance or file objections to the dispute resolution panel, and communicate to the assessing officer within 30 days of the receipt of this draft assessment order. If no reply is received within the time limit prescribed in section 144C, the draft assessment order will be final. After discussion, the draft computation of income is as under. Then what he makes that computation. And then what after the figures and all, we'll kindly see the just above the signature. Penal proceedings under section 270A will be initiated separately at the time of passing final assessment order. Demand notice and computation sheet are enclosed. So this was the draft. And what along with it came page 362, which is not the demand notice.
Actually, this was also a draft demand.
This can't be
at best.
Yes,
no demand could have been raised at this stage.
I'm not the kindly not take the penalty notice, which is not at page 371.
Yes.
So this was the notice note by which, although he said not that if he will initiate not, he also sent this notice.
This was to come at the time of final disposal. So anyway, this is also draft. I take it at best. And thereafter you.
But I filed objection.
Where is that objection?
Kindly have not look at not page volume 4 minute page 380.
Yes. 380.
It's a very first page, of volume 4.
Fair enough.
No, this is filed on 13th April 2021. And this is the covering letter and the.
No, this is on. This is dated 9th April 2021.
Filing date, it's mentioned is 13th April. The
Where is that?
No, there is a rubber stamp.
I can't read it. Anyway, filing is
13th April. And with the DRP directions.
Yes, where do I get it?
At page 454.
454.
But it's the, yes, same volume, page 454.
So this was under subsection 5.
My lords. And it also says, so, my lord, at page 454, directions of the dispute resolution panel under section 144C5.
So once this was done, so this was required to be completed within 1 month.
1 month from the end of the month, my lord, in which the order was
So
received.
according to you, since this period has lapsed, and in terms of section 153, no further proceedings can be initiated.
Yes, but because not this, the
153.
144C13 itself specifies not the time within which it has to be done. Otherwise, not the normal period is over long, much earlier. And what this was kindly seen at page 463, the directions, the operative partner of the direction note at page 463. Paragraph 11. Lord.
So this part has been not complied.
Then, and what the transfer pricing officer gave effect, but then still there was one more step thereafter. Lord. The transfer pricing officer, Lord, kindly see at page 465.
No, not necessary to go at this stage. That is final hearing. Yes, Mr. Rai?
Should be state.
Yes. Ashok. The present writ application has been filed inter alia challenging a demand notice dated 16 March 2021 under section 156 of the Income Tax Act 1961, hereinafter referred to the said act, including the notice dated 16 March 2021, issued under sections 274, read with section 278 of the said act. Full stop. Mr. Khaitan, learned advocate representing the petitioner, by drawing attention of this court to the draft order issued under section 144C.
C1.
144C1 of the said act submits that the petitioner had, by drawing attention of this court to the draft order dated, where is the date? The date of the order is?
No, it is dated not 16th March 2021, the same day as the notices note.
Yes, 16th March 2021. Issued under section 144C1 of the said act, and the response given by the petitioner thereto. Draft order under section 144 C1 of the said act, and the response given by the petitioner thereto. Where is that response?
Volume 4, page 380. Not that.
Yes.
First. These were the objections filed before the.
Dated 9th April 2021, which was received by the department on 13th April 2021. Comma. By placing this court submits that once an objection was received to the draft order within the time prescribed in subsection 2 of section 144C, it was for the dispute resolution panel, in short DRP, to consider the objection and take a decision thereon.
Yes.
Is it a decision or
directions? The directions. They have to give directions.
Consider such objection and issue appropriate directions thereon. First up, by referring to
page 454.
Yes, by referring to the order dated 31st August 2021, appearing at page number 54 of the writ petition, it is submitted that the DRP, on the basis of the objection raised by the petitioner, had issued appropriate directions, had issued specific directions on the assessing officer to pass the final order by incorporating the copy of the DRP directions as annexure thereto. Full stop. Although in terms of subsection 13 of section 144C of the said act, the assessing officer was obliged to complete the assessment, was obliged to pass the final order
Complete the assessment is the correct.
Complete the assessment, yes. I will just find the language what is used. Sir. Complete the assessment. The same having not been done, the respondents could not have enforced either the demand notice or the penalty proceeding already initiated against the petitioner. No, you recover. Could not have enforced the demand notice
or proceeding with the penalty,
nor could have sought for adjustment. They have sought for adjustment, nor could have sought for adjustment of the demand
under section 245.
Under section 245 of the said act. Full stop. Mr. Rai, learned advocate representing the respondents, seeks leave to file affidavit in opposition. Full stop. He submits that the instant application can only be decided on the basis of exchange of affidavits. Full stop. Having heard the learned advocates appearing for the respective parties and taking into consideration the fact that the assessing officer has not completed the proceedings within the time specified in section 13,
subsection
in subsection 13 of time specified under subsection 13 of section 144C of the said act, I am of the view that the respondents at this stage should not be permitted to enforce the demand arising out and in connection with the draft order dated 16th of March 2021.
For the assessment year 2017-18.
For the assessment year 2017-18. Till disposal
or proceed with the penalty notice till this.
Most of the respondents are accordingly restrained from proceeding with the penalty notice issued in connection with the aforesaid assessment proceedings. Full stop. The aforesaid interim order, না ওখানে আগে বললাম না till disposal বলেছিলাম না ওটা করব না the interim order lasted. The interim order shall continue for a period up to the end of July 2024 or until further orders, whichever is earlier. List this matter. None. Let affidavit in opposition to the instant writ application be filed within a period of 8 weeks from date. Reply, if any, there to be filed within 4 weeks thereafter. And 12 মানে 3 মাস July.
Up to August,
August, end of August. You want to file it earlier than that? No. Yes. Liberty to mention after expiry of the period for exchange of documents. Original side, the moment you mention will come up.
I'm grateful.
Grateful.
Hey, section গুলো ঠিক লিখেছো তো? না, লাস্টের পার্টটা। Proceedings you indicated under section
270 capital M.
270 capital M. লিখে রাখো penalty proceedings 270 capital M. আমি করে দেবো। ওই মিস্টার খৈতান learned senior advocate.
Item number 2.
This is my application. May it please your lordship.
Yes.
The subject matter of challenge in this writ petition is an order made under section 148 capital AD and also a notice under section 148 of the Act. On the ground, my lord, the assessing officer could not have assumed jurisdiction having regard to the time limit provided for in section 149 of the Act. Now, the assessment year is 2015-2016. And the
It is 3
period.
years.
No, it should be 6 years.
10 years.
It should be 6 years. It should be 6 years, having regard to the having regard to the proviso to section 149(1). But if a lordship kindly takes for once the relevant documents first. Kindly take, my lord, the
Why
first.
are you not agreeing to the limitation period? Both of you, you saying 6
My lord,
years,
this is a debatable issue. I tell you, lordship, this is a debatable issue. Several writ petitions are pending. In all those writ petitions, my lord, interim protections have been granted in favor of the assessee. I mean, carrying the orders also. And in fact, in those cases, my lord, if and when those cases are compared to the case in hand, we are better placed because in this case, the notice has been issued after expiry of 6 years, that is in 2023, when according to us, that is the interpretation which we are placing on, it should have been issued on or before 31st of March 2022.
When has it been issued?
Yes.
It has been issued when? After 6 years?
24th April 2023.
After 6 years.
After 6 years. Malad,
On the 7th year. On the 7th year.
Yes. Malad, the assessment year is 2015-2016. 6 years from the end of the relevant assessment year would take us to, my lord, 31st March 2022. 2022.
So it is 22-23.
They are issuing it in 23-24. Assessment year 23-24. In fact, financial year 23. I'm sorry. Financial year 23.
When has been issued, you said?
Sorry, my lord.
When it has been issued, you said date?
My lord, 24th April 2023. Financial year 23-24.
I see.
My lord, I can place some of the orders passed by this honorable court. Your lordship will find in the next page. In this case, my lord, the impugned order under 148A(d) was passed on July 28, 2022. And the assessment year is 15-16. And I believe, my lord, there are several petitions which are pending now. But, my lord, we stand on a better footing because in those cases, my lord, it would require interpretation of another act.
No, the honorable judge they had considered the matter on merits also.
Yes.
So you are not placing anything on merits. It's only on.
No, not on merits. Only on jurisdiction.
No,
only on jurisdiction.
Yes. Yes, justify the initiation of reassessment proceeding by relying on instruction number such and
But
such.
that is their case. That is their case. But that is a case for
He is also that is also relying on that same circular.
That's a limitation for TOLA. That will not be relevant. TOLA, I mean taxes and other laws, Amendment Act. That will not be relevant for this year because that was kind of an interim.
In the interregnum, there was you had the COVID period.
That those issues are taken care of. Once those issues are taken care of,
what is his stand? What is Mr. Dutt's stand on this?
That your lordship sees section 149.
No, I'm not going there. You know, re-argument. If this is the order passed by this court.
Not on this matter.
No, not on these matters. Obviously, similar matter.
Not similar. I will show you.
Want to argue? I can hear you.
I'll show you because 149 says that where the taxable tax escaping assessment.
It will take a little more time. That is it. Yes, I hear you.
For 1 minute.
Yes, yes.
If the tax escaping assessment is more than 50 lakhs, here in this case it is 5 crores. 10 million, it will be 10 years.
That is subject to proviso.
That particular amendment came in 2021.
21.
Along
with the proviso. They have lost.
Show me that.
Yes, table to
kindly
may I
take
just
149 of
kindly take what we have done. The provision as it stood before the amendment in 2021 and after the amendment in 2020. Now, kindly take the
Mr. Mojumdar will not hand over copies without verifying it. I'm sure.
Your lordship will kindly take,
Yes.
before Mr. Dutt makes his submissions, kindly take the provision which has been inserted. Actually, by Finance Act 2021, there has been a paradigm shift so far as the process of reassessment is concerned. The entire assessment proceedings had undergone a total sea change, total. And what has happened, what some aspects or some factors or some incidents were saved. Kindly take 149, as it stands now. Though it is this is as amended by Finance Act 2023. Kindly take Mr. Dutt is relying on this. He is relying on.
Not applicable for that particular year.
No, my lord. I tell you, your lordship, may I just indicate? 149, kindly take 149 1B. Kindly bear with me for 2 minutes.
Yes, yes.
149 1B. No notice under section 148 shall be issued for the relevant assessment year if 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books of accounts or other documents or evidence which reveal that the income chargeable to tax represented in the form of, Mr. Dutt relies on this: an asset, expenditure in respect of a transaction in relation to an event or occasion, or an entry or entries in the books of accounts which has escaped assessment or amounts to or is likely to amount to 50 lakh rupees or more. He is relying on this, the main provision. I am relying on proviso to this main provision. Provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before 1st of April 2021. Then, my lord, a deeming fiction is created. If a notice under section 148 or section 150, now this is not relevant, it's not a case of 153 A or C, could not have been issued at that time on account of being beyond the time limit specified under the provisions of clause B of subsection 1 of this section or section 150.
Beyond the time limit.
Yes. And as they stood immediately before the commencement of the Act, Finance Act 2021. But the interpretation would be, in my most respectful submission before your lordship, the interpretation would be that the main provision, insofar as the main provision is concerned, my lord, it would control all the assessment years commencing from, my lord, 1st of April 2022. So far as the proviso is concerned, my lord, and now the consultation is going on. I'm happy that the consultation is going on. Then the proviso is concerned, proviso will control any assessment year commencing on 1st of April 2021 or any preceding assessment year. This is a case of a preceding assessment year being 2015-2016. Now, my lord, the law as it stands, proviso says, if, my lord, so far as this law is concerned,
49 is generally in respect of.
Then, my lord, the law as it stood prior to Finance Act 2021 would have to be taken into consideration. That is the proviso says. Kindly take, my lord, as the case may be, as they stood immediately before the commencement of Finance Act 2021. Now, my lord, the right hand column is clear. I have given the earlier provision which says 149 1C. I'm sorry, 149 1B. If 4 years but not more than 6 years have elapsed from the end of the relevant assessment year, unless the income chargeable to tax which has escaped assessment amounts to or is likely to amount to 1 lakh rupees or one more for that year. Now, my lord, what has happened in this case, my lord, notice under section 148, my lord, your lordship may have come across several writ petitions where, my lord, 148D orders are challenged. I believe so, my lord. What the present regime requires, that prior to the issuance of a notice under section 148, a pre-adjudicatory proceedings has to be undertaken. That pre-adjudicatory proceedings commences with an inquiry under section 148 capital A, small a, clause A, followed by a notice under section 148 clause B, A clause B, followed by a reply or response on behalf of the assessee or by the assessee under 148 capital A small c, and then followed by an order, that is 148 A small d. And along with that order, if the assessing officer is of the opinion, yes, none of the submissions made on behalf of the assessee appeals to the assessing officer, he would issue not only the order, along with that order, he will also issue a notice under section 148 with necessary approvals from the competent authority. In this case, my lord, notice under section 148A(b) was issued. And my lord, in response to that notice, we took this point. It's not that before this honorable court for the first time, we are taking this point. So we took this point before the assessing officer that look, this is barred by limitation. So you do not have jurisdiction to make as a reassessment in terms of section 148, in terms of section 147, preceded by a notice under section 148. You cannot issue. The assessing officer says, he places the interpretation that no, this would only mean that only the assessment years prior to the any proceeding initiated after commencement of the Finance Act 2021 would be governed by the main provision and not controlled by the proviso. That is the interpretation. I take your lordship to that portion of the order for once.
Not necessary at this
Well, at this stage, my lord, at this stage,
why affidavits are necessary? Final disposal, this can be.
yes, this can be decided. And my lord, in the meantime, my lord, I am seeking a similar protection.
No, what protection?
That is several matters. None of the orders have been challenged by revenue. Let them say that they have challenged any of the interim orders. If they are, my lord, Mr. Rai is smiling because he is in the next matter, none of the order has been challenged, and I can get 4 or 5 orders where Mr. Dutt was appearing. And as usual, Mr. Dutt has been very fair.
Of the orders where Mr. Dutt is
There are several orders, my lord.
I am not disputing that. But
So, my lord,
What do you want to submit? Tell me.
this matter can be disposed of.
yes, not certainly. And in the meantime, my lord, this protection can be given.
By holding that, the main section is only for the main section, it would apply for 10 years.
Yes.
And for the proviso, it is 6 years.
No, he has misled you.
No, I will not mistake. Well, that
No.
neither Mr. Dutt will
He
mislead.
did not mean it that way.
Well,
He
neither
did not mean
Mr. Dutt will mislead, not I will mislead.
He did not mean it.
But our interpretations may be misleading.
Yes, what
I
do you want to
have
say?
got written instructions from my department.
What written instructions you have?
It just now came on mail.
Yes.
Yeah, so
Well, the written
No,
instruction.
what instructions you have?
according to the department, section 149B, 1B will be squarely applicable. And since this is a case in which,
In his case also.
in his case also.
Very well. Then that's been decided.
It has to be decided.
Yes.
Not in the motion stage. Yes.
And he agrees.
I don't agree.
Present petition has been filed. Inter alia. Questioning and inter alia challenging a notice dated 23rd March 2023. Kindly hear. Notice dated 23rd
Well,
March.
24th April.
Both
23rd
notices
and
were challenged.
I'm sorry, 23rd and 24th. My lord,
Yes, both.
both.
Notice dated, no, notice is dated 23rd March 2023 and the notice dated 24th April 2023 issued under section 147, 148, stroke 148A and 148 within bracket D of the said act respectively. এইভাবে দুটো প্রথমটা এইরকম আর এত including all subsequent proceedings based on the said notice. By placing reliance on the provisions of section 149 within bracket 1 within bracket B of the Income Tax 1961, it is submitted that
it's proviso we are relying on. It's a proviso.
yes, 149 within bracket no, with proviso,
We are relying on proviso.
proviso to the Income Tax Act 1961 as amended by the Finance Act of 2023.
2021. This is same. It's all the same.
With effect from 2021, April.
No, no, your submission is that
Yes,
as
Malati.
per the finance amendment of 2023 in terms
No,
of the
it's
proviso.
2021. Malati, the printout I have given, that is Finance Act 2023, but it is all the same. It is as amended by
April
Finance Act
2021.
2021. But there is no cabin. There is no cabin.
1st April
First,
2021.
the
Wait,
Finance
wait,
Act
as
21.
amended by the Finance Act of 20 on sections 149, proviso to section 149 of the Income Tax Act 1961. না আগে here in a select বলা আছে বলা নেই so Income Tax 1961 and the proviso thereto it is submitted in as much as the notice under section 148A capital A within bracket small d
D, my lord, D.
D small d
Malati, no. Malati, it is an order under.
where is that notice?
Malati, it's when the 148 D is the order.
Oh,
and 148 is the notice.
yes, 148 notice under say 148.
Malati, that is 148 D order is at page 59.
No.
And 148 notice is at page 57. 57 and 59. Your lordship is looking for the B1 also?
No.
Not necessary.
কোথায় আছে বলো? In as a notice under section 148 of the said act pertains to the assessment year 2015 and 15-16 and has been issued on 24th of April 2023. The same is beyond the time prescribed, beyond the outer limit of the time prescribed, and as such, no proceedings on the basis thereon would have been proceeded against the petitioner. First up, according to Mr. Mojumdar, learned senior advocate representing the petitioners, the aforesaid reassessment proceedings initiated by the respondents is without jurisdiction and no order on the basis thereof could have been passed. The order dated 24th of April 2024 appearing at page number 56 of the writ application is also without jurisdiction. Mr. Mojumdar.
23.
24th of April 2023.
Page
57.
57.
57 is the notice.
And my lord,
where is the
and
order?
59.
59. না অর্ডারটা বলে দিচ্ছি order dated 24th of April 2023 appearing at page number 59 of the writ application is unenforceable as being as the same is barred by limitation. First up, Mr. Dutt, learned advocate representing the respondents, on the other hand, submits that in terms of section 149 within bracket 1 within bracket A within bracket B of the said act, it is well within the jurisdiction and authority of the respondents to initiate proceedings under section 148 of the said act.
Within 10 years, if
within the authority,
if it is more than 50 lakhs.
Correct.
Below 50 lakhs, I can't.
Since we have within the jurisdiction. Inasmuch as the said notice has been issued within 10 years from the date of assessment. From the date of assessment. Full stop. Heard the learned advocates appearing for the respective parties and consider.
But from the end of relevant assessment year. 10 years from the
end.
From the end of the assessment year.
2015. 10 years from the end of the assessment. The learned advocates appearing for the respective parties and consider the materials on record. Full stop. Prima facie, it appears. Prima facie, since it appears that the petitioner has been able to make out prima facie, since it appears that the notice under section 48 of the said act may have been issued beyond the time prescribed. I am of the view that the না কি বললাম ওখানটা সরি বলুন No, no, no. Yes, prima facie, since it appears that the notice under section 148 of the said act has been issued, may have been issued beyond the time prescribed, beyond the time prescribed in the act. They shall be the respondents shall be restrained from proceeding with the reassessment, proceeding further with the reassessment proceedings and not from enforcing the same. Full stop. Enforcing the same. The aforesaid interim order shall continue for a period. Aforesaid interim order shall continue till the end of August 2024 or until further orders, whichever is earlier. The respondent shall be at liberty to file their affidavit in opposition within a period of 3 weeks from date. Reply, if any, there to be filed within a period of 2 weeks from date. Liberty to mention after expiry of the period for exchange of it. Sure.
Will your lordship kindly fix it in the
Liberty to mention after expiry of the period is easier for you. Original site, the moment you mention, it will come up. It will come.
Item number 5 is, your lordship, similar matter. The dates would be different, your lordship.
No. I have to check up each and every matter, you see.
No.
Difficulties. I'm sitting here taking up this jurisdiction now. So give me some more time. Thereafter, it will be easier for me also.
No.
Otherwise, I would have passed the order.
Have the advantage of my lord's order when I move the matter.
Dekhi. Identical matter.
Identical matter, your lordship, only dates. Item number 3.
No.
Item number 3.
I take your lordship's kindly.
So identical matter, your lordship. Same assessment here. Only the dates and the pages would be slightly.
Notice at page 148.
No, that is at page 58, your lordship. 69, your lordship. 69.
69.
My lord.
69. 69.
Yes, your lordship.
168 148 the date
Date would be 24th April, your lordship.
24th April 148 in notice. 24th April 2023. And final order?
The order is at page 58, your lordship. It's the 148 AD order, your lordship.
Paragraph, the present writ application has been filed. Same date order, 24th April 2023. Same day notice, same date order.
But actually, the initial notice, your lordship.
This is a draft order.
No, your lordship. The initial notice of 148 AB, that is at page 47, man.
Say so.
March.
The present writ application has been filed inter alia, challenging a notice issued under section 148 capital A within bracket B of the Income Tax Act 1961, hereinafter referred to the said act, as also the final order, as also the order passed under section 148 of the said act.
148 AD. D. Capital A, small d.
Notice is yes, AD, same AD of the said act, dated 24th April 2023. Baki gulo shob act, which same direction.
The pages, my page would be in the previous order. My lord had mentioned page 58. In this 58 in this case, your lordship.
It is 58 and 47. 2 pages are there. Hey, the sticker diye diyechi. Puro debo.
I'm grateful, your lordship.
Yes. Yes. Which is your matter? Actually, here. Same, identical, no. I would have hired.
I was tempted to say that it's an identical, but it is not identical. But I've been able to serve and they are here at least. That is a thing I have done.
What is the matter?
Here, there was a partnership firm that should.
Yesterday you were submitting that.
It should transfer into a limited liability partnership under the Act. And now they are proceeding
No.
10 crores, my lord, they are proceeding.
You'll get a chance on Monday.
I won't.
Why?
It's an urgent determination. That's the problem.
No, it's also urgent matter.
That again, that remains in the discretion of a judgment. If it comes up in the matter.
Quarter to 5, quarter to
No,
5.
I understand.
Should not. No, ordinarily should not. No, it's
No,
most
I
necessary.
Only millet one prayer millet Monday millet I have some personal difficulties. Tomorrow only your lordship can.
I will not consider that.
Tomorrow millet your lordship can take up tomorrow millet tomorrow.
Kindly take it tomorrow millet for an exception millet. Kindly millet.
Ordinal side determination I don't have.
I know millet, but
only on Mondays, Monday to Thursday.
I know the determination lies in your lordship's hand.
No. This is the usual practice I follow. You'll place it on Monday.
And Monday there again.
Tuesday.
And millet, I'm telling something which I shouldn't be. The authority is the same authority who is the assessing officer. He had received the matter on 15th, still did not appear. Then again, yesterday we saw
assessment order passed, statutory appeal is there, milord. Why milord the learned senior friend is placing the writ petition? I do not know, milord.
Because it is
statutory appeal is there.
If you're not appearing on Monday, ensure nothing happens on Monday.
Nothing will happen Monday.
Yes.
None.